Families? You're going to be the third one to dock this one. Third case. Thank you. Good morning, everyone. Welcome to the DC Court of Appeals. Before the argument starts, if you can please turn your cell phones off or put your cell phones on mute. Thank you. Court will be starting in 2 minutes. All rise. All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals. You are there and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please be seated. Come to order.
Morning, everyone. We have three cases on this morning's calendar. The first of them is TYREE Jackson versus United States, number 22 CF 617. We'll hear first from counsel for Mr. Jackson.
Good morning, Your Honors. I'm Ann Keith Walton, and I represent appellant TYREE Jackson. And I will reserve 2 minutes for rebuttal. And I hope that everyone can hear me okay. I'm wearing a headset. Okay, great. So in this case, the trial court erred by excluding relevant evidence of bias relating to pending investigations of misconduct and sustained findings of misconduct with respect to the 3 police officers, witnesses who testified at Mr. Jackson's trial. The trial court also erred by precluding a meaningful degree of cross-examination of the officers, which was a Sixth Amendment violation. I will be specifically addressing the information contained in the MPD Personal Performance Management System, which is referred to as PPMS. And this information was provided to defense counsel by the government prior to the trial beginning. And the trial court was also able to review the PPMS information. I think it's helpful to consider the argument in 2 parts, and these would be the pending investigations of misconduct, and the second issue would be the sustained findings of misconduct. So beginning with the pending investigations, the trial court allowed defense counsel to ask some questions about the pending investigations for all 3 officers. It did not ultimately allow counsel to ask the officers about the specific allegations. Now, it is true that the trial, yes.
I mean, I think in the pretrial ruling, the Superior Court did say, you have to walk a fine line here. You can ask about what you believe to be the allegations in the report and what you believe them to be based on. You just can't ask about the underlying allegations, obviously, because of Fifth Amendment concerns. And so it strikes me at the outset there was leeway given, and then the defense counsel just didn't take full advantage of it.
That's right, Your Honor. The initial ruling, I believe, was ambiguous. But the initial ruling did seem to indicate that the questions would be allowed as to the specific allegations.
Can I ask you just to clarify that ambiguity? Yes. One kind of question is what the general nature of the allegation is. Here is the alleged misconduct described in a phrase or something like that.
Right.
And then the other is, okay, let's get into the weeds of that. Who did what did, what was the evidence? What did you say? Who said what? And it seemed to me, at least the original ruling was trying to distinguish between those 2 things and to authorize defense counsel to indicate to the jury what the general nature of the allegation was without getting into a mini trial of what the, in the details of it were and what the officer's conduct may or may not have been. And you're saying you think that that's not so clear, and instead that ruling in isolation, in your view, was ambiguous about what it was permitting as between those 2 things?
I believe that that the initial ruling was a bit ambiguous because it didn't seem to address whether defense counsel could ask just was the pending investigation for use of force, or whether defense counsel could ask a few more specific questions. Such as, is it true that you're being investigated for allegations that there was a tactical takedown or a team takedown to the ground and then potential injury to the defendant? And I believe, yes.
Counsel, I'm sorry, but those, you're just getting now into what the allegations actually were. I mean, are you suggesting that the trial court had to go through those themselves and tell you that you could ask about each of those? I mean, it seems like it was actually a broader grant of what you could do when it said, the court said specific allegations against them. and their knowledge of the allegations. And so that would seem to subsume what the allegations actually were, which are the things that you're taking off now. So I'm not sure what the ambiguity is.
Well, I think the ambiguity also lied in the fact that there wasn't a thorough discussion about it. And so then the trial court, the trial court kind of indicated then, let me know what you're going to ask before the officers testify. And so that is the point where the real problem lies, because I think I acknowledge that the initial ruling was more expansive, or it could have allowed the, I guess, defense counsel to at least, maybe be more specific as to what exact questions she wanted to ask. But then once we got to Officer Choi, when the defense counsel started telling the trial court what exactly she wanted to ask, the trial court started saying, well, you can ask, is there a pending complaint? It was a complaint made to the Office of Police Complaints? Was there a referral to the United States Attorney's Office? But there was no indication that she could ask anything specific about the allegations.
Was there anything, if you were going to point to I get your point that
Right.
there's an ambiguity intrinsic in it if there's a line between a general description of the allegations and something that's more specific, like how general is allowed and how much is too specific. Is excessive force the general description, or is it discharge of a firearm? So there's that ambiguity for sure in the original ruling.
Right.
It did seem as though the original ruling authorized some general description of the character of the allegation, not just the fact of an allegation without more. And you're saying now that when the rubber hits the road and they start doing the cross, the trial court doesn't kind of on its own volition clarify, oh, by the way, here is the exact line I have in mind. But I tend to think that it might be, your argument would be stronger if there are places in the transcript where you think the trial court foreclosed some general description of the nature of the allegations rather than simply kind of continuing to leave it unclear in your view. So are there, you're going to point to the transcript where you think, okay, here, the trial court is basically not just leaving things a little unclear, but saying, nope, can't do even a general description of the character of the allegations. Is there a place you'd point us to?
Yes, I'll just have to, because beginning with Officer Choi, beginning with the initial ruling, it was also troubling that the trial court was focused on the Fifth Amendment issues, and stated at some point that the Sixth Amendment wasn't an issue. And if you'd like me to give you a reference to the transcript.
That I recall that comment, although
Okay.
that again, that's a little murky at best, because if the trial court is saying, here's what I plan to allow, that's going to be fine. The Sixth Amendment's not going to be a problem because I'm going to allow you to do what the Sixth Amendment entitles you to do. That's one way of reading the trial court's comment, rather than that, what your client has no Sixth Amendment rights to cross-examine witnesses against him, which seems like a somewhat implausible view to attribute to the trial court.
Okay. So there was at one point, the trial court says when Officer Minzak was testifying, it was clear that the trial court didn't like the way that defense counsel was asking the questions. And I will agree, defense counsel could have asked the questions better. And so we are stuck with the exact proffers made by defense counsel, though I don't think the defense counsel has to be too specific as she's making a general proffer as to what she wants to ask. And then the trial court starts telling her exactly what questions to ask. But I see it with Officer Minzak.
So with Officer Minzak,
Yes.
After there is this colloquy and these objections to the form of the question, the jury gets excused and they kind of return to the topic of what is acceptable. And there the court says that defense counsel can ask him about his understanding of the complaint and what he faces if he is found to have committed the misconduct. And so that to me seems to allow for all of the Curry bias questions that the defense counsel would have wanted to put on. And so are you thinking that it was unclear after that type of cross-examination was acceptable?
Yes, and I had just pulled that up. I see the court says, if you want to ask him what his understanding of the reason is, you can ask him that, but not what the actual reason would be. So, and I think the way that the trial court was telling, let's see, and then, oh, I'm sorry, I'm just looking for I know I have where the trial, okay, so there's one point where the court starts saying, I'm going to tell you right now the 2 questions that I'm going to allow you to ask. If you ask something different from this, I'm going to stop you. You can ask him, are you aware of MPD General Order number 90107 that says that members can only use of force that is objectively reasonable, for example. So that's when the trial court starts articulating the exact questions that defense counsel will be allowed to ask. And I think that by doing that, trial court just, I guess a reasonable assumption could be made that no additional questions would be asked. So the defense counsel cannot, yes.
You read it in context, it seems much more like defense counsel, you seem to really be struggling here and getting a bit off base. These are the kinds of questions you should be asking to, be in accordance with this sort of fine line that I've drawn. And I don't know, I don't see anything in there as sort of limiting it to just those two questions. And it strikes me that obviously this was a sort of contentious and difficult trial, and the trial court was just trying to kind of put defense counsel, to the task that she was clearly struggling with how to get these questions out.
Right. I do. I agree that it became very contentious, and but I still see it as the trial court started limiting questions more and more. So as by the time they got to Officer Joseph, who was the last one to testify, the judge just said, I'm only going to let you ask a couple of questions in just the way I told you to ask them. So, and then it wasn't until just before closing that the trial court said, oh, I would have allowed you to ask a few more questions. But so at that point, it seems right before closing, the trial court's clear on what he would have allowed defense counsel to ask. But while these officers were testifying, the trial court never said that.
The trial court did have an interest in protecting the Fifth Amendment issue, the Fifth Amendment rights here too. So this was somewhat of a balancing. And I mean, we don't have to get into the, exact balance of court strikes between the Sixth Amendment and the Fifth Amendment when they collide. But, these are instances where trial courts have to exercise a greater degree of involvement in the questioning when there is a risk of butting up against a witness's potential Fifth Amendment rights. So this doesn't strike me as something that we've found problematic before. The trial court's level of involvement in the questioning has to vary depending on the circumstances. Would you agree?
Oh, I agree. And the Fifth Amendment is obviously a important consideration for those officers. They were all being investigated for the same misconduct. And I understand the U.S. Attorney's Office didn't want to provide immunity, and so that had to be, fleshed out. And the Sixth Amendment did have to be balanced, but that could have been avoided by saying, you can ask whether a complaint was made for, taking the defendant to the ground and then the defendant complaining of an injury. But I think the confusion got to where the trial court believed that defense counsel and the government was worried that defense counsel was going to say, didn't you, right, to the officer, didn't you, push the defendant to the ground and then injure him, something like that. I think that's where the focus started sort of beginning, because I did trials for many years, and I know defense counsel can attempt to ask those questions. But it just should have been made clear that you can ask about, whether it was use of force, what the specifics were, but you can't ask.
Can I ask you?
Right.
It's a little ambiguous, I guess, to me at least, exactly the scope of the right to cross-examination and what detail you're arguing is a constitutional entitlement here. So. At times you seem to be focused on kind of a description of the allegation in somewhat more general terms, but just a minute ago you seemed to say, getting into the particulars of it. And so is it your argument in this court that your client actually had a right to cross-examine, not just about was this use of force, but more specifics about, well, like what was the nature of the use of force? Did you shoot a gun? Did you throw someone to the ground? So some of the specifics is your argument that you have a constitutional entitlement, your client had a constitutional entitlement to that?
Well, yes, I believe he should have, let's see. Let me try to say it in a non-confusing way. I don't believe my client had a constitutional right to start accusing the officers of something in a manner in which they would have had to have, isn't it true that you pushed the defendant to the ground and injured? That wouldn't be an appropriate question because you do have to take into consideration the officer's Fifth Amendment rights. But I believe it was in Howard, which was a case cited by the government, where Judge McKenna had a pretty clear ruling relying on longus, that defense counsel would be allowed to cross-examine the officers in a little bit more detail. And the defense counsel did end up cross-examining the officers with several specific questions about what they were actually alleged to have done, not in a manner in which they were having the officer admit or deny, just being able to expose a little bit more detail to the jury so that they could be, fully informed, of the extent of the motive to curry favor or the extent of the lack of credibility of the officers.
Counsel, I know that you had indicated an intention to talk not only about the pending investigations, but also about prior discipline. Your time's expired. If you want to take a minute to at least take a stab at the prior imposed discipline, and feel free to take a quick stab at that.
Okay, I'm sorry, the time goes by so quickly. So as far as the sustained findings, I think the trial court limited those questions to the motive to curry favor due to the escalating discipline. But I think the defense counsel did make a proffer as to their credibility and potential corruption bias. But
and could you be specific about, because your opponent argues that in fact that point was really never, the sort of corruption bias theory as opposed to a motive to curry favor bias theory was never presented to the trial court. So you said you believe that defense counsel made a proffer about that second theory. Again, where would you point us to in the transcript where you think that was brought to the attention of the trial court?
Well, I would say it was when when the defense counsel said it goes to their credibility and the fact that's on their record and the fact that they all add up. And I realize that that's a bit confusing, but I think
the first of those applies fully to the motive curry favor line of thinking. So I'm not sure that would be a very clear signal to the trial court that there was a separate theory. Now the other two were it's on their record and it all adds up. That seems pretty imprecise or unclear.
Well, I actually think that maybe you're missing part of the sentence. She says it goes to his credibility and his reason for wanting to curry favor with the government, and they all add up. That to me seems to be entirely within the land of curry favor bias.
I can't I can't argue that defense counsel made the most clear proffer that could have been made, but I believe that she made a general Sixth Amendment claim for bias, and bias is expansive, under Jones and Longus. And it's not just corruption bias, it's all bias, credibility, everything. And so I think the fact that, the willingness, there was a, let's see, I think that in Jones, the commission of or commitment to engage in illegal or impermissible acts may serve as evidence of bias. And for example, having 8 findings, sustained findings of misconduct, like Officer Minzak did, would go to that. The commissioner commitment to engage in. Sure.
I'm leaving aside how concretely the issues were presented in the trial court. I guess I'm a little unsure about that too. I mean, an employee can be disciplined by his employer for lots of reasons, like, failing to safeguard property of the employer or failure to show up, coming late to work or things. And so without knowing more about the nature of the particular instances and without having some description of why they might go to corruption in some way, rather than just not a great employee, not following all the rules and regulations, it is, I guess, a little hard to see how just like this person was disciplined by his or her employer 8 times would provide much of a good faith basis to suggest to a jury without more the person is corrupt in a way that means the person should not be believed.
I understand, Your Honor, and I think the trial court had the PPMS information, so they could have gone through the sustained findings, but defense counsel, I agree, did not press the issue, trying to go through every single one of the 8 sustained findings. So we have what we have in the transcripts. But she did, proffer to the court, there's 8 sustained findings, and immediately the government says, well, there were only PD 750s as a form of discipline, and they only stay on the record for a year. So we're only going to allow this one sustained finding where there was one day of leave or something like minor. And the government offered no evidence of that, or of the 750s only staying on your record for 1 year. And I just think when it got to that, the trial court just accepted what the government said and said, okay, that's the only thing you can ask about. But that was I think that was overly limiting ruling to the defense counsel.
Okay, counsel, I think we have your argument. You asked for 2 minutes of rebuttal, and we'll give you that, and we'll hear now from counsel for the United States.
Thank you.
Good morning, Your Honors, and may it please the court, Michael McGovern on behalf of the United States. This court should affirm Mr. Jackson's convictions because the trial court permitted defense counsel to cross-examine each of the officer witnesses about both their pending investigations and prior sustained findings of misconduct to the extent that cross-examination was relevant to those officers' motive to curry favor bias, which was the only bias that the defense counsel proffered to the court these instances were relevant to. In particular, the court not only permitted defense counsel to ask about the pending nature of the investigation, it allowed them to ask about the officer's knowledge of the specific allegations at issue, the fact that a referral was made to the United States Attorney's Office, and the potential outcomes they would face if either the United States Attorney's Office brought charges or the Office of Police Complaints sustained or found credible the allegations of misconduct. Now,
Can I just ask you, I'm interested in particular in one of the phrases you just stated, which was that the trial court authorized inquiry into the specific allegations. And is that a quote from the transcript where the trial court uses the word specific, or is that your gloss on the trial court's ruling? And if it's the former, I'd be interested in getting into the page.
So I can't represent that they never used the word specific, but I will point you directly to the April 13th transcript on pages 23 to 24. And this is the discussion of pending investigation cross-examination prior to trial, before any of the officers had testified. And in that discussion, it was the government who, after an initial discussion of what the trial court thought was permitted, which preceded the part that I'm about to point your honors to, the government states that it believes that the scope of what the trial court has allowed cross-examination is, and I'm quoting here, questions such as, and this is page 23 at the bottom, are you aware of an allegation of excessive force? Are you aware of an allegation where an individual was, suffered an injury as a result of this force? And then goes on, are you aware of the potential sanctions you could face? The trial court responds very specifically to the scope that the government is proposing. And immediately on page 24 of the transcript states, I think that the defense ought to be allowed to go a bit further than that. And to say, do you understand or do you know that in this complaint, it is alleged that you did X, Y, or Z, whatever it is. And so in that exchange between the government counsel and the court, I believe, Your Honor, it is clear that the court is going further than saying, you may ask whether this was an excessive use of force allegation, but in fact, defense counsel is being permitted to ask the nature and the specific allegations of that use of force. Defense counsel simply didn't do so. Having not done so, defense counsel can't come into this court and complain that it wasn't permitted to do cross-examination that it was in fact permitted.
Okay,
to
so I
do.
mean, I think, I can generally agree with you that at least the initial ruling was pretty favorable for the defense. But I think the argument is more that as the cross-examination proceeded, limitations on the questions proceeded to cut back on that ruling in a way that was overly limiting. So I guess that's where I would want you to maybe focus right now.
Sure, Your Honor. And I disagree with the characterization that the court cut back on its ruling about what the permissible scope was. Certainly, the court engaged in multiple colloquies with defense counsel about the questions she was asking and their appropriateness. And in each of those colloquies, the trial court was pointing out the defense counsel was not being precise. In all of the questions that she was posing to these officers, she was not being precise in the manner in which she did so. And so he continued to offer suggestions as to how the questions could be phrased so that they were both precise and
were they imprecise in a way that implicated the court's concern about breaching Fifth Amendment rights here, or were they simply imprecise and the court's attempt to control the questioning then had the collateral effect of infringing on the defense's Sixth Amendment rights? Does that question make sense?
It does make sense, Your Honor. I believe that the court's concern was that I believe at one point he refers to them as sloppy. And I think that in the background, as Your Honor noted, there is a concern that if these questions were to be perceived as asking the officers directly about the substance of the investigation and what they did or did not do, that could cross into an impermissible area that would implicate their Fifth Amendment concerns, for which there was no need because the Sixth Amendment right to cross-examine could be fulfilled by accurate and precise questions as to what this officer's motive to curry favor was. And so I think you have to view the transcript in its totality, because it wasn't just these questions on which there were discussions about the proper scope of cross-examination. There were multiple times that the court was concerned with the imprecision of defense counsel's questioning. And so as the trial went on, the court became more involved in discussing what was the appropriate. But in none of those interactions did the court ever say that she was not permitted to ask about the substance of the allegations. And when I say substance, I mean the actual allegations themselves.
Can I take you to one exchange that I find a bit troubling, and that is at the bottom of page 112 of the 413 transcript. And this is when they're going back and forth about the sustained allegations. And the trial counsel is trying to ask about it seems like she's trying to ask about the facts underlying that allegation. And when that is unsuccessful, the court says, remember, I told you, you can ask him in the context of the possibility of escalating discipline. And that seems to me to potentially be saying, that's all you can ask. Are you aware that this could lead to escalating discipline, as opposed to what was the nature of that substantiated finding?
And Your Honor, I think here the reason is because that's the distinction between the sustained findings and the pending investigations. So I'd like to actually break that apart for a reason. The pending investigations, the reason that the court allowed inquiry into the nature of the investigation is because, as Judge McKenna found in Howard and defense counsel referenced, there's an idea that the jury needs to be exposed to the nature of the allegations, how severe the potential penalty could be, given how severe the conduct at issue that is alleged is. That goes directly to the motive to curry favor. With respect to the sustained findings, the theory upon which there is a bias or motive to curry favor is that having this sustained finding on your record can subject you to increased discipline if there is a sustained finding in the pending investigation against you. And so the crux of—
Isn't the theory a little bit different from that? Because the way you were stating it, it is that in fact, the prior sustained discipline could increase the severity of the consequence for the pending investigation. I would have thought that for impeachment cross, the question would be a little bit different, which is what the officer believes on the topic. And so it seems like even if it's not true necessarily, or you couldn't establish that it's true, that the prior established disciplinary infractions would increase severity, you might be able to inquire of the officer, well, you do have prior sustained, and do you understand, that's how you might want to word it, that those could affect the severity of the sanction imposed upon you with respect to the pending matter? So is it really turn on what actually is the case or what the officer believes is the case?
Well, so with respect to motive to curry favor as a general legal matter, it turns on what the officer believes. That I think I will say affirmatively. The question I believe
And I don't mean to derail you from responding to Judge Alicon's question.
But I believe that has to be viewed in the context of what does the Sixth Amendment line with respect to what is information that the jury needs to be exposed to understand what the officer may or may not believe about his potential for facing escalating sanctions. And it's not altogether clear that the nature of the prior sustained finding, the actual finding, whether it be a damaging of police property, a preventable accident.
But that seems wrong to me. I guess let me start with the threshold that because these are past sustained findings, there's no Fifth Amendment problem, right? I think we agree.
There's no discussion certainly in the.
So if that's the case, let's say there were 8 sustained findings for use of force and you're being investigated for use of force. I mean, it strikes me that the nature of the sustained findings might be entirely relevant to whether they'd be escalating or not. Because if all of your other ones are you're late to work and you're being investigated for excessive use of force, I could see how they wouldn't be relevant. But so you would need to know the nature of the underlying allegation.
Potentially. And I think this raises a concern in the background of the Sixth Amendment issue, which is that the Sixth Amendment question that's at issue is inherently fact specific, because the test is whether or not additional cross-examination would give the jury a substantially different view of the witness's credibility. And so there has to be some indication that or argument that the nature of that prior finding would give the jury more information. So perhaps where the sustained finding is the same as the particular finding that they're under investigation, that might be a situation in which a court might say, I do believe that you should be able to inquire specifically about the nature of that. Perhaps if there were facts that they engaged in the same conduct, that would be relevant, but that's a case-specific inquiry here. And that wasn't not only presented to the court here, but isn't actually at issue given the nature of the particular sustained findings that this defense counsel was attempting to introduce at this trial.
Can I ask you about a different passage in the same on the same general topic that I also was interested in? This is, I think on the, gotta make sure I get the date right here, the April 14th transcript, I think before the cross-examination of Officer Minzak about what I think may have been 8 or a number of prior sustained disciplinary infractions. And the United States tried to cut off cross about even the existence of all but one of them on the theory that if you look at the actual regulations that govern progressive discipline for MPD, things that were more than a year old would not be taken into account in determining the discipline for the pending matter. And the trial court ended up agreeing with that determination and said something, this is on page sorry, where is it here? This is on page 7. Says you need to be to defense attorney, you need to be able to establish as a legal matter you need to be able to establish that the prior finding in fact could subject the officer to greater discipline. That seems to me, this is apropos of the question I was asking earlier, that seems to me not quite right and unduly stringent relative to what leave aside the Sixth Amendment, but just a party's ability to cross-examine would be. Wouldn't the issue instead be whether there was a good faith basis to inquire of the witness what the witness's understanding might be about the existence of those prior sustained infractions and the consequences of it for the severity of a sanction on the pending matter?
So I think what's clear, Your Honor, is that the court was placing on defense counsel the onus for substantiating that there was a good faith basis to ask about.
You say good faith basis, but the trial court uses the word actually.
Correct, but the defense counsel, I'm sorry, I was referring to a prior at the very beginning of the trial. The court was very clear that it was placing on anyone who desired to do cross-examination based on PPMS information, the burden to come forward with the relevance and the basis for it. Defense counsel simply said these all add up. Yes, the court's language seems unduly restrictive here, but the reasoning of the court is that in the absence, I believe, or read into it, in the absence of an order, which that order would inform the officer's knowledge of what may be used against them or may not, without the absence of that, there's no basis for saying that these will be used. You can't come in and assume.
I say I don't mean to interrupt, but I do mean to interrupt, so I apologize for interrupting. Maybe it would be a better way of saying it. I guess it's just not obvious to me why the defense attorney here wouldn't have had a right to say, look, I don't know these regs. I don't know if the officer knows the regs. And I'm just trying to suggest to the jury that this officer might be pretty concerned about this pending matter. And part of the reason a reasonable person might be concerned about it, who may or may not know the regs, would be, this will be number 9 for you. And, why wouldn't there be a good faith basis to say to the officer, you have this pending matter, could have some serious consequences. Are you concerned? You've had a number of other ones, and this would be number 9 for you. Are you concerned that might affect the severity of your sanction? Why wouldn't you have a good faith basis to ask that question without having to wade into what actual regulations might or might not say about all that?
So I think, again, this is going to be a fact-specific inquiry, that if defense counsel comes in and has a good faith basis, taking, for example, an officer who has 50 or more priors and says, look, there's more, that may weigh on whether or not it is more appropriate because the number somehow indicates that they may be particularly concerned about getting another. But there still has to be a good faith basis for belief that, in fact, these would have some effect on
that. I don't get.
Well,
assume that the officer was completely wrong and there's no good faith. Imagine that the officer had, you had reason to know that the officer incorrectly believed that those prior sanctions, those prior sustained findings would be very damaging. You'd be able to ask the question. So you don't have to have a good faith basis to believe that, in fact, those prior determinations would be adverse. But an officer might fear that. Is that, or am I wrong?
So I will agree to the extent that you said that if you have a good faith basis to believe, this officer would believe that. And the question is, where is that in this record? And that is absolutely not there. Perhaps defense counsel could have made some type of argument looking at the nature of the allegations of the prior sustained findings, their frequency, perhaps the timing of it, the particular dates that are at issue here. But simply saying there are 8, which, just to correct the record in this court, there were 7 that actually related to this officer. One of them that was included on the chart was not actually after review of the subject documents with respect to this officer. So there were 7 that spanned multiple years. And there is a regulation which does indicate how long certain information stays in officers' files.
Well, that you represent that now, and that was represented in the trial court. That regulation is not in our record, or is it?
That's no, Your Honor, it is in the supplemental record. So in the discovery letter that was included with the PPMS reports, this is Exhibit A of our additional discovery, there is a footnote, which footnote 9 explains the basis for escalating discipline and cites to the regulation. The regulation has since been amended, but that is on page 4, footnote 9 of that letter. So in fact, there was information that was available. And to the extent that defense counsel believed that there was some other basis for saying, even absent this regulation, perhaps in an official manner, this couldn't have been used, but this officer would be particularly concerned about that. It is the defense counsel's obligation to articulate that so that the parties can discuss that, so that they can determine whether, in fact, there is a good faith basis for believing there may be some motive to curry favor based on escalating sanctions, based on the potential for one of the pending allegations being found to be sustained. So unless the court has any other questions on either of the sustained findings or pending investigation, we would ask that the convictions be affirmed.
Thank you, counsel. We'll hear now from Ms. Walton. I think she has 2 minutes for rebuttal.
You're on mute, Ms. Wall.
Thank you. Sorry about that. I think I guess a couple of issues. The government's focus on the initial ruling is misplaced because, I mean, what happened is I talked a lot about this, so I'm not going to belabor the point, but I think Your Honors actually pointed to good parts of the transcript where the questions became troubling, especially with Officer, I think, Minzak, where the judge actually says, just ask him, sir, you know that someone filed a complaint against you, and then the complaint was filed with the Office of Complete. I mean, the judge actually just told the defense counsel what exactly she could ask, and it would be very difficult for defense counsel to then glean from that she would be asked to that she would be allowed to ask more questions. I think that's the problem. And then the other issue is that the government's insistence that defense counsel have to be absolutely specific in telling the trial court what questions she's going to be allowed to ask. I mean, if the trial court had wanted the questions, the government asked for defense counsel to provide the questions. The trial court said, no, we don't need that. But then once the defense counsel started asking questions, it was no, 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 objection, objection, sustained. And then the trial court saying, no, you can ask this, that, and the other thing. And never saying that the defense counsel could actually ask about the allegations. So the real problem with this case is that through the testimony, regardless of the initial ruling, throughout the testimony becomes so restricted that by the time defense counsel got to Officer Joseph, the trial court just said, just ask a few questions in the way that they'll ask. I'm going to stop the questions. And defense counsel was so shaken up at that point. I think that she had made her point. She had tried to ask questions over and over and over again to no avail. And at that point, I think, the question becomes, what exactly does the defense counsel have to say to the trial court? Am I allowed to ask the question in this particular manner, or she's not preserving the record for appeal?
Ms. Walton,
yes.
do you agree that for each of these officers, defense counsel was able to elicit testimony that they were aware of an investigation or a disciplinary finding, and that they were aware that that could affect their employment status?
Yes.
Or other status? Okay. And
Yes.
so I guess then, to the extent we see any restrictions, that to me, since the sort of heart of the motive to curry bias had come out, would not rise to the level of a Sixth Amendment error. Do you agree with that?
Well, Your Honor, I think the Sixth Amendment allows for more thorough bias cross-examination. I think as a part of the thrust of my argument is that case law also supports that the counsel should be able to draw out a bit more information so that the jury can explore the extent of the motive to curry favor, or the extent of the bias. So I think when the defense counsel's only allowed to ask, I guess when they're only able to draw out the fact that there is an investigation and that the investigation could affect employment, that deprives the jury of knowing about the extent of the potential bias of the officer.
Thank you, counsel, for both sides. Thank you for your briefs and your arguments. And the case is submitted, and we will move now to the second case on this morning's calendar. In Re LATIF DOMAN, number 22 BG 578. And once you're ready, Mr. DOMAN, we'll hear from you.
Good morning, Your Honors. My name is LATIF. I'm the respondent in this case. I asked to reserve 5 minutes of my time for rebuttal. We're here today because of this check. This check does not have IOTA on it. If it had, I never would have used it because my firm had a practice of not using checks to distribute client funds or any monies to my client.
I take your point. So TD Bank made a mistake. As a result of their mistake, they made a mandatory referral to the bar. The bar then opened an investigation, and I don't think the bar contends that this check was not a mistake, but in the course of investigating to ensure that it was TD Bank's mistake as opposed to your mistake, they found other mistakes that you had made. And so I take you almost to be arguing that because the TD Bank error caused the referral, once the mistake was taken, everything should have stopped. But it strikes me that if ODC found through the context of their investigation that you hadn't been keeping the requisite records or that you hadn't been, I guess to start on the records, why wouldn't that be a basis to proceed?
I appreciate the question, Your Honor. First, they did not find that I made any other mistakes. All they found was that this check was issued. This notification was sent to them. What they did was when they got this check, they issued a subpoena in addition to sending me a letter, an inquiry letter, asking me to explain what the cause of this overdraft was. As this court knows, an overdraft may be caused by bank error, attorney misconduct, or something worse, perhaps some type of intentional conduct. That wasn't the case here because the document immediately showed that it was in error. It does not say IOTA. TD Bank is a DC bar.
You seem to think that the result, the fact that there was an overdraft as a result of this check was solely the bank's fault.
It was.
And well, so let me ask you this way. I think the way disciplinary counsel looks at it, if you had been keeping the records they believe you weren't keeping and had been monitoring your bank statements, you would have realized long before there was any overdraft that this mistake had been made and would have corrected it before there was an overdraft. And what's wrong with that line of thinking? This had been going on. I mean, before this check resulted in an overdraft, I mean, the mistake had been made a fair while ago, and there had been numerous checks drawn out of what you, if you hadn't been further checking, might reasonably have thought was an operating fund, but really was an IOTA fund.
Right. There's a presumption here that I wasn't looking at my bank statements. I wasn't, because I was going to the bank and getting receipts. I was doing my real-time account balancing in the moment. I wasn't necessarily looking at my bank statements to determine what money was coming out of my operating account, or at least what I thought was coming out of my operating account, and what was going into my IOTA account.
And I mean, part of the reason that people check their bank accounts is because banks make mistakes. And so that one could take the view, and I think disciplinary counsel takes the view, that it is incumbent on an attorney who's responsible for entrusted funds not to simply, without checking and keeping records, assume, well, I'm sure the bank is doing everything correctly. So the disciplinary counsel faults you
again, Your Honor,
for not realizing this mistake before. Everybody agrees the bank made a mistake. The question is sort of what follows from that.
What follows from that is that the bank made the original mistake. So on the first check that it gave me, I couldn't have checked the bank statement to determine that the checks were bad. The first check that I wrote was already bad because I relied on the bank to give me a proper check. I didn't check it. It took maybe 10 checks before I discovered that the accounts were that the checks were wrong. But that wasn't my fault. It wasn't my error. It was the bank's error. But that's not what's.
But it's an error you would have noticed if you had looked at the bank statement, or while you were at the teller window, looked at your balance and thought, oh, that seems incorrect.
Again, I cannot argue that I missed the bank's error, right? I missed the bank's error, but that doesn't make the bank's error my error. The board ultimately found that I violated.
No, but what I think basically one way of looking at the way things spun out is there was an overdraft, which I think you agree it was appropriate for disciplinary counsel to look into and see what was going on. That's part of the job. So of course they need to look into it. They get an explanation from the bank that there was a problem, but it leads you to wonder, well, like, why wasn't that problem caught earlier? Are there adequate records being kept? Are there other problems here? And that's what they started to investigate. And from their perspective, then they ran up against refusals to respond and failure to produce records that led them to conclude, and then ultimately led the board to conclude that there were other infractions that were committed.
There were no refusals to respond. The board and the hearing committee found that I responded to every interrogatory and document request that they issued.
Well, I guess that is a question about the meaning of the word respond, but there was a refusal to provide requested and subpoenaed documents. Is that accurate?
Right. I certainly made an open refusal, which is permitted under the rules.
Well, I mean, you think you have an attorney who has been asked or maybe subpoenaed by disciplinary counsel has an absolute right to say, sorry, I'm not responding to your request. I'm telling you, I refuse to give you the documents. You have an absolute right to do that?
That's certainly not what I'm arguing. I wouldn't argue that. What I argued, what I explained, and what I did was that I explained to disciplinary counsel that this was an error that was not caused by me, that the subpoena that they sent to me asked for an exorbitant amount of information that would not explain how the bank erred, or even explain how I didn't catch the bank's error. They asked for 12 months of bank records for both my operating account and my IOTA account.
Why would that inquiry not shed light on why that mistake by the bank was not caught by you earlier?
Well, number one, they asked for 12 months of bank records and an unlimited number, no temporal limitations on the supporting records that they wanted me to produce with regard to each and every transaction in that 12-month period in the IOTA. So they asked me for any documents that would support a year of transactions in the IOTA, which is a voluminous amount of information. It was asking for supporting records that were created years before this litigation.
I mean, how do we know it was voluminous? I mean, I don't know how many transactions there were.
I did, because I turned, and so did disciplinary counsel. I turned over the bank statements.
And how many transactions?
There were 130 transactions. And at that time I had 29 clients. Disciplinary counsel didn't know that. I knew that. Rule 1.6 says, I just can't turn over my client's confidential information unless they've complained or there's a court order that compels me to do that.
Can I ask you what is your basis for asserting, as you do now, that the requested information would have revealed attorney-client confidences? It would have been, I guess, transactions with clients. But what's your basis for saying that the bank records or other requested records, all of them, or even any of them, would have revealed client confidences? Well, that's a reasonable question, because that's what when I first got the subpoena, I didn't understand what disciplinary counsel was asking me for, because they didn't ask for specific records. They just said, turn over supporting records. It was a non-specific demand for everything in my files. At the hearing, we asked disciplinary counsel's forensic investigator, what documents were you looking for? What documents did you need to be able to complete this investigation? And he said they needed my retainer agreements, my settlement agreements, my invoices, my communications with my clients about changes in fees, those sorts of things. Those are all confidential documents. They have confidential information in them. And I didn't understand why disciplinary counsel needed that information when they had a clear, they had a letter that I provided from the bank explaining that the bank made the error, that the bank had not informed me of its error. That
counsel, this may be in the record, but just can you remind me? I mean, it seems like you were challenging the subpoenas on both attorney-client privilege grounds and burdensome grounds. And so what were the level of negotiations or discussions about? One, redactions, and two, narrowing the scope?
Yes. In my first letter to disciplinary counsel, a day after I received the subpoena, I reached out, I sent her, said, hey, this document is an error. I don't know why. I have an overdraft coming off of my account. I have to go find out. Then I called her disciplinary counsel shortly after that, saying, please, I'm getting with the bank. It's clearly an error. Can you withdraw the subpoena? Because the subpoena is asking me to pull a whole bunch of information together when I'm going to get this letter from the bank. I got the letter from the bank. But before I got the letter from the bank, I reached out to disciplinary counsel and asked her to reduce the scope of the subpoena at least to 3 months, because Rule 1.6 says that I can't turn over that information without my client's consent, and that I was required, I apologize, I was required by the rules to ensure that that I could not turn over those documents without communicating to my clients that they had a right to object to turning over that information.
Is
So
that
I
right?
should have reduced it to 3 months because I had 29 clients in it. She
But is
reduced it
that
to
right?
3
I mean,
months.
would you have been able to redact?
Right, I would have been able to, I would have only had 4 clients if she had reduced it to 3 months. And then that would have been a manageable number of clients that I could have reached out to and told them, hey, I've got the subpoena, they're asking for your information. Is it okay? Or at least I could have focused the argument for the appeal to the board when I filed my motion to quash. She just wouldn't cooperate at all in any way. She kept issuing more and more discovery, making more and more demands that I couldn't respond, that I just simply couldn't respond to. And I made it clear to her.
I'm still, I guess, a little unsure about your basis for believing that there actually was an impediment to your responding. And your opponents rely on the decision of this court in Ray Confidential.
Sure.
And then I also am just more generally unsure about the extent to which, like all of it, I mean, it would be one thing if you had turned over some documents that were, like bank statements.
I did that.
Immediately.
I turned over a transaction. My first response, Your Honor, included the bank's letter, a transaction list that identified all the transactions that occurred in the IOTA so that she could see exactly.
And there's a dispute about that document, but leaving it aside for a minute. Did you
There's
turn
no
over-
dispute about what was in the document. There's a dispute about what I said at the hearing, but there's no dispute about what was in the document and the accuracy of the information in the document. So what they got from me.
In any event, did you turn over the actual bank statements?
No, I didn't.
And
No,
why not?
I-
Did you?
the
is
bank
there- is there-
turned over- the bank
I'm
turned
asking
over.
whether in response to the subpoena you did, and if not, do you have an attorney-client privilege reason for not turning them over?
I hate to get into the utter details of this, Your Honor, but the reason that I didn't turn over the bank statements immediately was because disciplinary counsel sent me a letter saying, if you don't turn over these records immediately by I think it was February 27th, I'm going to file a motion to compel. So I stopped what I was doing. I went to the bank to ask them for these bank statements for the 12-month period. The bank said we couldn't get that out to you in the manner of time. So they helped me create the transaction list that I turned over to the bank, that I turned over to disciplinary counsel. They said they couldn't get the.
Can I make sure what you just said was the bank helped you create that document?
Yes,
What
Your
you
Honor.
just said? Okay.
Yes, Your Honor.
But you would agree that with respect to some of the documents that were requested or subpoenaed, there would not have been an attorney-client privilege impediment to your turning them over.
No, Your Honor.
I think there would have been an attorney-client.
I don't know
privilege.
I don't know what documents they were asking me for. If you look at the subpoena they asked for each and every document supporting document related to each and every transaction account. They never told me what documents they were looking for. And 1.15 says that the documents that I'm supposed to keep to maintain my account has to be, I forget what the phrasing is, it's some fancy phrasing, but essentially it has to be all the records that somebody could look at if I'm not present to be able to determine what the transaction was. So it means they would need my retainer agreements, my settlement agreements, they would need any communications and change between me and my client, between the changes in cost and in terms of changes in fees by the time that the transaction in the accounts were submitted. So they were asking for a plethora of information. It wasn't clear to me exactly what they were asking for, but I tried to produce what I thought was relevant, and what was relevant was explaining how this check error occurred. That's count one, but I want to say on count one that the real issue before the court is 8.4 D, whether or not I improperly refused to turn over my records. And that's a question of good faith. The hearing committee made it very clear that I had a reasonable belief that the information that disciplinary counsel was asking for in the subpoena was overbroad and unduly burdensome, that the information that disciplinary counsel was asking for included attorney-client information, and that I had a right to resist that. 1.6 says that I had to respond, 8.1B says I had an obligation to respond to disciplinary counsel's inquiries subject to constitutional limitations. I raised objections to disciplinary counsel subpoena, reasonable objections that the hearing committee found, reasonable objections that the board found. Yet the board concluded that my objections were not proper, that I inadequately informed.
I thought you just said that the board found your objections reasonable.
Yes, the board actually, if you look at the board's ruling, the board adopts many of the hearing committee's hearing committee finding. The board concluded that I did make multiple objections, not just limited to privilege.
I was just tied into the word reasonable. Where in the board's report and recommendation do you think the board said that your refusal to turn any virtually anything over was reasonable?
The board, I'm trying to think, it was a long opinion, but the board made certain findings. The board made certain findings that clearly indicated that it recognized that the materials that were being asked of me included materials that were privileged and confidential.
I thought the board relied on in-ray confidential, a case that I have also asked you about,
Right.
to say that in fact that was not an objection that someone in your position was in a position to raise.
My time is elapsed, Your Honor, but to answer your question, yes, they did make, I'm sorry. Disciplinary counsel knew that the records. It's been 10 years that I've been dealing with this, Your Honor. 10 years that I've been trying to get someone to understand that what they were asking me for minimally, all they had to do was withdraw the subpoena, allow me to talk to the 4 clients if they had reduced it to 3 months, and we would not be here. That's not what they did. Instead, they burdened me with more and more and more demands that were not relevant to its inquiry. And the only question was whether or not I had a good faith basis for resisting their demands. And if disciplinary counsel had taken the time to share with the motion to quash committee, that when I filed my motion to quash, if disciplinary counsel had shared with them the bank's certification of the TD Bank letter that I gave them, right? Because this is what happened. I provided disciplinary counsel the letter explaining the error. Unbeknownst to me, 2 weeks later, disciplinary counsel issued a subpoena to TD Bank. TD Bank responded and provided verification of the TD Bank letter that I sent to them. But disciplinary counsel went to when I filed my motion to quash, disciplinary counsel told the board that TD Bank had not objected and suggested that TD Bank was cooperating and suggesting that the TD Bank letter was not genuine, when in fact it was. And there's been no dispute. There's been no dispute. With regard to, I'd like to quickly address count 1, the ACAB award. Disciplinary counsel was fully aware that an ACAB arbitration said that I did not owe my client any money. Yet disciplinary counsel filed a petition not mentioning that ACAB award, saying that I owed my client $2,200 in a retainer fee. Now, the client had complained to the disciplinary counsel saying that she wanted a copy of her file, and she wanted her $2,200 retainer fee back. Disciplinary counsel reached out to me. I immediately sent the file to disciplinary counsel so they could turn that file over to her. But I told disciplinary counsel I had earned that $2,200. I guess the process before disciplinary counsel was taken.
I mean, maybe that's part of the atmospheric here, but there's no count alleged against you relating to retaining that fee.
But there is, Your Honor.
Well, I guess
everything in count 1 flows from the representation that was arbitrated fully by ACAB. And so when they're suggesting,
why is that? The ACAB award doesn't really explain its reasoning, as they typically don't. The award, it just says, you would counterclaim for $8,800 and they didn't, grant your counterclaim. And they awarded the $2,200 and an additional filing fee number to you.
Right.
But I don't think there's anything that tells us whether in making those determinations, ACAB figured out and made a determination as to whether your representation on the discovery matters that were at issue was competent or incompetent.
Your Honor, you just made the point that in addition to denying the client the $2,200, ACAB awarded the $700 that I had upfronted for the client to file her lawsuit. Why did I have to file that lawsuit? Because the EEOC had erroneously dismissed her case. The board, the ACAB said that I was entitled to, because that filing was useful to the client, that I had preserved her claim. They said that she owed me the $700.
I mean,
so they ordered her to pay me that.
You might infer that from the ACAB's order.
No, you don't have to.
ACAB's order doesn't say that.
It does say that. It says she owed me the $700. They would not award $700 for services that disciplinary counsel saying were not useful. That just wouldn't happen. So necessarily, that's what they decided. They decided that the lawsuit that I filed in federal court was a useful lawsuit because it preserved her claim. So the suggestion that I did something wrong by abandoning the EEOC's hearing because the judge was making error after error, and so to preserve my client claim, I moved her over to the federal court to give her a de novo.
Do you know whether the question of the competence of, is there anything in our record, let's put it this way, that says that this issue about whether your handling of the discovery dispute in front of the EEOC was competent, whether that was even presented in any way to the to ACAP?
It was, and
does our record indicate that? Is there anything in this record that tells us
it would
that?
have, Your Honor. However, because disciplinary counsel waited 3 years after the arbitration occurred to investigate the matter, even though they knew about it, they waited 3 years, and the ACAP said, we burned the file. We burned the file after 3 years because they would have seen the entire record of what was presented to the ACAP. But because they waited so long, because they decided when they couldn't find anything in my bank records in count 2, they came up with this nonsense about going for this old complaint from ACAP and then bringing this lawsuit. I'm bringing this whole process against me. My time has elapsed. I'll sit down now.
Okay, you had asked for 5 minutes in rebuttal, and we'll give you that. So we'll hear now from counsel for Office of Disciplinary Counsel.
May it please the court, Jack Metzler for the Office of Disciplinary Counsel. I would like to start with Mr. Doman's handling of client funds in his trust account, because it underlies not only the commingling charge, but also the record keeping charge, the interference with the serious interference with the administration of justice, and in particular impeding the disciplinary investigation, Mr. Doman's lies to the hearing committee, and ultimately the sanction. We know from Mr. Doman's testimony at the hearing that he understood his obligation to segregate client funds from his own funds in a trust account. And he testified to this at length. He understood that he was supposed to deposit client funds, including unearned advances of unearned fees, that those belonged in the IOTA account, but that his money did not belong in that account. And that included earned fees, that is money after money that had initially received from the client, but since had been earned.
Can we slow down on that? Because that's where I do get puzzled about this theory of commingling. So if, let's say I'm a new lawyer and I get a $2,000 advance on fees, so they're unearned. I've read in remans and I realize I got to put them in trusted funds, and I do that. So they're in my IOTA account, and then I start working for my client and I bill in 6-minute increments, and I work for 6 minutes. Well, now some of that is earned. Am I commingled because I haven't taken it out? It seems like it can't be instantaneous commingling as I earn it. So how does it work?
I think that's
how does it
right.
become commingling? How promptly? What is the regime under which I have to remove it from when it was entrusted after I've earned it? I just don't quite see what the regime is for that.
Sure. So the preamble to the rules say that they are rules of reason, and they're supposed to be applied in light of the circumstances. And of course, we know that these things don't happen instantaneously. There's a reasonableness component, and so I think the rule that you would apply if you were for your young attorney is they need to remove that amount from the account within a reasonable time given the circumstances. So
That's
maybe
tough,
if you're,
I mean, that's a tough.
Well, for example,
concept. Commingling is a serious infraction.
Sure.
And it seems like, maybe you have an idea of how, maybe is it every month, if I do my billing every month and I take it out at the end of the month, you would say probably reasonable.
I would agree with that.
3 months, maybe reasonable, maybe not. It just seems like a tough burden to put on attorneys that they're guilty of commingling unless in retrospect, they removed earned funds from entrusted funds with reasonable promptitude. Have we ever said anything like that?
I'm not sure that there's a case that specifically tells you exactly when what that time would be. But I think that is because the rules, not just the rules, but our investigations and the complaints that we bring, we're not going to bring a case for someone for keeping money in an extra 5 minutes.
Yeah, but
or,
it does
5
seem like
minutes.
it's presented here because your commingling argument, at least here, I don't think this is how you briefed it or argued it below, is based on the sort of mathematics of what was going in and going out. And so it seems like we would need to know when it would have been unreasonable to leave things in order to sort of determine how any of these monies had worked. And I guess I would sort of compound that with your expert, I think also said he could not determine whether or not commingling had occurred. And so I sort of share Judge McLeese's concern, and I'm wondering, do we need to address that question in order to even consider your argument about commingling?
Well, I think the answer to your ultimate question is no, and the reason for that is that if you look at what I understand to be your ultimate question, do you need to consider when it would be reasonable to take out funds? I think the answer to that is no. Mr. Doman testified not only that he left earned fees in there or that he deposited fees he knew he had already earned. I mean, this is throughout his testimony. That was $1,000. It was earned. I know it was earned, he said. But I put it in there because a lot of times people may someday dispute whether I owe that money back to them. And so I'm just leaving it in there so I know it's there just in case that ever happens. Well, that under any definition is not.
How does that support your own expert's testimony that he couldn't determine if they unearned fees and earned fees existed in the account at the same time? I mean, under sort of the theoretical possibility that they always exist in there at the same time, then I'm just at a loss as to.
Well, I think I'm not sure exactly which what bit of testimony you're referring to. Much of the testimony that Mr. Doman quotes in his brief is more about whether what our investigator thought he could identify, based on his own observations. But just because but I don't think that precludes this court from looking at the record. And
I mean, I think there's a pretty specific site in the board, both the board and the hearing committee found that commingling was not proved, and they relied on what they took to be your experts sort of saying, throwing up his, I think, hands and saying, I really can't. That's how they were characterizing the testimony. And it was, I think, like 934, 935 of the hearing transcript.
sure.
So I think it's pretty clear what testimony they're referring to. Are you saying you don't think that could be reasonably viewed as your own expert witness saying, well, I can't really tell whether there was commingling or not?
I think just because one person looking at it, if he wasn't looking at the right things at the right time, in the way that I've suggested in our brief that this court should, the fact that he wasn't able to find it doesn't mean that this court can't.
Well, we're not really in the business of finding things. And so the question before the hearing committee was whether commingling was proved by clear and convincing evidence. And the way the hearing committee looked at that, which the board also looked at it, was that's a heavy burden. The ODC's own experts said can't tell. I don't think it was proved by clear and convincing evidence. That seems like an uphill battle to overturn. And it's not really for us to find something. And in particular, it gets hard, as Judge Ali Khan mentioned, if this mathematical theory that you have presented in this court was not presented previously. And so there's a question here at the end of it. Sorry for the prologue, but the question is it right, as Judge Ali Khan's question seemed to suggest, that this math approach to there must have been commingling because we can tell from how much was in, what was entrusted, and what was the back end. As a matter of math, there was commingling of funds. Was that a point that was presented to the fact finder or to the board, which was reviewing the determination of the fact finder?
Well, I'm not sure that it was. And with regard to the briefing before the board, I think it's important to keep in mind that the hearing committee in this case found no violations whatsoever, except for the record keeping violation. And as we mentioned in our brief, I think it's relevant in looking at the hearing committee's report that two members of the committee expressed in so many words that they were influenced by their views of the disciplinary council and the people who bring disciplinary complaints that were not part of the record. And so I think it's appropriate. Those are inappropriate contexts. They're unfortunate. And I think it's appropriate to consider those in how you look at the hearing committee's report. But with regard to
Can you be a little more concrete about that? So normally we would look at a hearing committee determination of a pure question of historical fact. If the hearing committee said not proven by clear and convincing evidence, we would approach that quite deferentially. Are you suggesting that we should be applying a different standard of review to that determination on this topic because of the general concerns
Well,
that you've
so
identified, or?
the conclusion that that commingling was not proved by clear and convincing evidence is not the sort of factual conclusion that this court would or the board owes deference to. That's a question of ultimate fact, which the court has said in Crane and other cases is essentially a conclusion of law and is reviewed de novo.
Yes, fair enough in part. But to be more precise, then the question of whether, assuming that there's no dispute about the definition of entrusted and unentrusted funds, which is maybe let's hold that assumption for a moment. It may or may not be an accurate one. The question of whether entrusted funds on an accepted legal definition and unentrusted funds on an accepted legal definition were in the account at the same time, would you agree is a pure question of historical fact?
Well, let's see. I think it could be, yes. And that actually answers your earlier question, Your Honor, about whether this court is in the business of finding facts. You don't need to find facts that add up to commingling here. The hearing committee found the hearing committee, the board found these facts, and you'll find them. The board goes through and says in November 2011 there was X amount. In December of 2011, X happened. In January, there were these deposits and these withdrawals. And at the end of January, there was a deposit, which was unearned fees. It was, entrusted fees. At the beginning of that period, there was a deposit, which the board found was entrusted, was Mr. Doman's property, in that it was earned fees. And throughout
during that time period, back to another aspect of the topic that Judge Ali Khan's questions in mind we're focusing on. How quickly, in your view, would earned and trusted fees have to be removed? Or do you think we don't have to answer that question because the math doesn't turn at any point on the failure to remove earned previously entrusted fees?
Well, with regard to that period, I think that's correct, because the entire period had one amount of money, about $32,000, which, it was giving Mr. Doman all the benefit of the doubt that had to be either his funds or entrusted funds in order for there not to be commingling. So once you get past that, that same amount was commingled with attorney funds at the beginning.
Why couldn't it have been partly entrusted, previously entrusted, but now earned fees that hadn't yet been removed?
Well, I think this might get into the question you were discussing earlier, is like when it would be.
Right, that's why I'm asking. That's why I'm asking whether your math question is independent of this legal issue that we were asking questions about.
Right. So, I understand what you're saying, and so I think the answer is the obligation of Rule 1.15 is that an attorney is supposed to segregate their own money from the client's money, and what this argument and the other argument that which I'm happy to talk about sort of the entirety of 2012, when he was writing checks unknowingly from the IOLTA account. Depends on Mr. Doman's sort of own testimony that he was putting extra money in the IOLTA account, his own money, and he admits this. He says, for example, at one point there was $30,000 that was added. He said, I got that money from my sister. She holds on to my money. I took my money that I expected to use for a case and put it in the IOLTA to keep it separate from my other money, right? So this doesn't necessarily, back to Judge Alican's question earlier, you don't have to make any conclusion about whether it was appropriate to leave money in there too long to conclude he shouldn't have been just depositing his own money in there and using it for.
That gets us into, I think the same question, right? Like, let's say you have 6 months to remove the money and he deposits the money at month 1. Is it unreasonable if he sort of put it there thinking, okay, well, I want to get some other accounts in order and then I will move it all out?
No, Your Honor. When he puts his own money into the IOLTA account, it's unreasonable at day 1, at day 0.
Well, if there are entrusted funds there, it's commingling. If there aren't any entrusted funds in there, then you're putting it in the wrong account, but it's not commingling.
Yes, I agree with that, but yes, as a general matter, I mean, it's maybe it's not a commingling, but it's still not the way you're supposed to treat a trust account. And Mr. Doman explained why he did it this way. And this is at page 582 of the transcript. He said, look, maybe I was leaving money in there too long. It was my money, but the only person I was hurting was myself, presumably because he didn't have access to the money. And he says this again on page 584 and 586. I wasn't hurting any clients. I wasn't hurting anybody. Well, the court has said the opposite. The court has said that commingling is inherently harmful to the clients because the prohibition on commingling isn't intended to protect him. It isn't intended to protect client funds. So the danger that he put his client funds in is when a creditor comes calling and says, I would like access to that money in your account. He can't
So
say.
I take that point. Your time is running short, so I was hoping to shift you in a slightly different direction. So the sanction that you are asking for depends, I think, on a finding of commingling. So if we don't find commingling, what is your view of the appropriate sanction?
I still think the sanction is the same. Two cases that we relied on are Bradley and Lyles. And those are cited in our brief.
That seems strange to me because we consider commingling to be quite serious. And so you're saying that this is the same sanction regardless of whether we have this really significant problem or not.
Well, I'll say this. The most important thing about our sanction recommendation is that there be a fitness requirement because Mr. Doman has shown through his testimony and even his briefs that he thinks this system for handling client funds was not just permissible, but was a good system, was a fail-proof system.
Did you ask for fitness below?
I don't recall off the top of my head. I believe we did.
My recollection is that before the board, the request was for a 1-year suspension without fitness. But you don't know what you asked for in front of the board.
Then
I could be wrong.
If that's right, then we were unfairly generous, I think, in that recommendation. I think the appropriate sanction is 6 months with fitness. But so I do hear your concern, and certainly it would. We think that it would be appropriate. The sanction is ultimately in the court's hands, and if the court believes that a greater sanction is appropriate, then it should impose that. But the cases that we cited involve incompetence plus the violation of Rule 8.4, and in those cases there were 6 months with fitness, and the court.
Although in one or both of them, the incompetence, rather than being as it was proved here, if it was proved a single instance, was more chronic. So and can I ask you about the general form of reasoning? So the sanction argument as presented to this court is, here are a couple cases that we think are similar that have a sanction that is like the one that we're asking you to impose, court. But the board, when it said, Aldano, its recommendation said, here are some cases that we think are similar that support the recommendation we're making to the court. And ordinarily, the brief, when disciplinary counsel is arguing, don't defer to the board's recommendation of sanction. That'll be a part of the board's, the disciplinary counsel's brief. That will be, yes, and although the board identifies some cases that the board says are similar, they're really not, and here's why they're different. And I just didn't see that. And the reason that can be important is, although the board tries to be consistent in its recommendations, and we try to be consistent, we do defer to them within a range of reasonableness. And so a lot of times, if you look at a particular case, you can find a spread of possible analogs, and we might well defer to the board, even though there might be a case that would support a harsher sanction that's somewhat comparable, if there are also comparable cases that are consistent with the board's recommendation. So
sure.
Do you want to take a stab? I know one part of your argument is the board's recommendation rested on the conclusion there was no commingling. You think that's incorrect. If you add in commingling, a whole different equation. Oh, that's some tension with your argument that subtracting commingling doesn't make a difference. But do you want to take a stab at arguing with respect to the cases that the board thought supported its recommendation, why you think they're not really comparable?
Sure. Yeah, I'm happy to do that. The board's recommendation sort of said, well, an isolated instance of of incompetence by itself can have a very low sanction. And so we think that's not that big a deal. And the court also said, well, a single instance of 8.4D serious interference, there are some cases where that has resulted in a very low sanction. Although I would note that if you look at the parentheticals of the board's opinion, you'll see that those 8.4 cases largely involve fitness, which we are asking for and which the board did not impose. And often in those cases, some of them were conditional, like what they involved was a refusal to provide records where the board said, well, if you give them the records they want, we'll suspend it, or if you comply with what we say, then you won't have fitness. But in the Nagel case, this court has said the typical sanction for a violation of 8.4D for impeding the disciplinary process includes fitness, and the court cited collected cases holding that. And there's a recent case which is cited in our brief where the only difference in the violations between the board's report and this court's report was the addition of an 8.4D, and the only difference between the sanction was that the court added fitness for that reason. So if you take one message from my argument about sanctions, it is that fitness is really the most important thing that the court can do. If you take 1 month or our recommendation of 6 months, we think that is appropriate. And we explained why in our brief, but primarily I would consider that Mr. Doman, even in his reply brief, is saying that this system he had for handling client funds was a fail-safe system. He says in his testimony that he understands the rules. He talks about what the record-keeping rule requires, and he talks about what 1.15 requires with regard to keeping client funds separate. But his actions show he deliberately decided not to do that. He deposited his own funds, he deposited earned funds, and he didn't keep records so that he could identify what was in the accounts, which money was his and which money was not. And I'd like to add one thing back to the commingling point. The sum of the argument that if the bottom line to the sort of line of questioning in Mr. Doman's argument is, if an attorney keeps bad enough records, records so that we really can't tell what was going on, even if he admits that he was putting his money in the account all the time, even if he says, essentially, I wanted to keep a buffer in there, and he says this in his testimony, the point was to protect myself from commingling. So he wanted to keep extra money in there all the time, so that, because he knows he wasn't opening the statements, right? So he knows if he's going to do that, he better keep extra money in there of his own money so that he can protect himself from a commingling charge. Well, that's just not what the rule requires. And what this court has said is there's the prohibition on commingling. It's not to protect the lawyer, it's to protect the client. And that's because when a creditor comes calling, he won't be able to segregate those funds and say, that's all client money. He won't even be able to say how much of it is his and how much of it isn't. That's what the record keeping violation shows. And as to, I would just like to address a couple of things that he said in his argument. He said, maybe
you'll need to be pretty brief because your time is up. So try to.
Okay, I will be very brief on this. He said that it took him maybe 10 checks before he realized. It was 90 checks. It was a year. And it was not until disciplinary counsel said, what about this bounced check, that he actually figured out that he was writing checks on the wrong account. And then as to the one document, he says, I provided bank records. And he says now that the bank helped him create. Well, that's not what he told the hearing committee.
Can I know we're trying to wrap up, but I have a quick question on that point. So it's an aggravating circumstance. The hearing committee found that the statement was possibly mistaken, but not intentionally false, and it based that on a credibility finding. Under Crane, what level of deference was that finding owed, and was it applied here?
So
by the board?
I looked through the hearing committee's report and I didn't find the kind of credibility findings that that Crane talks about. By looking at his demeanor, we believed him. They were more sort of status-based findings. He graduated from a good law school. He was at a nice firm and things like that. So I don't think that that's a kind of credibility determination that Crane says can affect the outcome. And I also think the ultimate fact that the hearing committee held was sort of was not that was that, well, he could have just been mistaken. His own testimony, as went through sort of exhaustively by the board, shows that this wasn't some sort of unintentional sort of mistake. He repeatedly, over and over the course of many several different hearing days, explained in great detail how he had gone to the bank and the bank had given him this document. I couldn't have created it. He now says today, the bank helped me create it. He said, I couldn't have created it because I don't have that software. And yet on its face, the document could not possibly have been created by the bank, but because it contained information known only to Mr. Doman about these particular transactions. So I to the extent that that the hearing committees made a finding about that, I think it should be discredited as not being supported by substantial evidence.
Thank you, Counsel. We will hear now from Mr. Doman in rebuttal.
Thank you, Your Honor. Just a couple of quick responses. First, the case that says that what I was doing with my account in terms of leaving money in the account when it was supposedly moved, in Ray Mance is very clear that an attorney may leave the money in the case that has been provided to them by a client that's not yet earned. You can deposit it in your IOTA account and leave it there until you want to remove it because you've earned it, or until the end of the representation. That's exactly what happened in my case. There's no evidence that anything else was happening other than that. That's what the hearing committee found.
But
that's what the board found.
Did you testify that you left it there after it was earned and after the case had terminated, just in case there was a fee dispute?
What I testified to be more specific, was that I may have done that because I didn't sit down with my books yet. But what I had no actual notion in my mind that monies in my account were mine and I had not moved them. Perhaps I had not sat down at my desk yet to do the accounting to make those transfers. But the suggestion that I intentionally left my own money in there to commingle is just simply not the case. I didn't testify to that. I wouldn't testify to that. Secondly, I was being asked about In Re Confidential before, and In Re Confidential does not apply to this case. In Re Confidential says that a Rule 1.6 violation or Rule 1.6 Rule 1.6 doesn't shield an attorney from having to respond to a disciplinary counsel subpoena. I wasn't arguing that. In Re Confidential wasn't arguing that. In Re Confidential was about 3 client complaints. It was on a motion to compel that disciplinary counsel filed. And the court had either narrowed their subpoena to 3 clients or disciplinary counsel had narrowed its subpoena to 3 clients. And the court said, this is a reasonable subpoena. The attorney needs to respond. That's not what happened in my case. Disciplinary counsel never filed a motion to compel. There was never any clarity on what they were looking for. There was never any reduction in the demands they made. And I was simply trying to get before court like what happened in Re Confidential, so a court could determine what the appropriate scope of disciplinary counsel's demands were.
Am I correct that the board found that you never lodged an objection to ODC? You never said, I'm not turning these over because of attorney-client concerns?
The board said that and didn't say that. So the board said that I did not adequately inform disciplinary counsel, which was a shifting of the burden. I'm supposed to inform disciplinary counsel that they need to file a motion to compel, which is absurd.
No, I mean, it seems like you get a subpoena and you say, I'm not going to respond to this because I.
And that's exactly what I did.
Well, because my concern is X, not,
Right.
I'm not going to respond to this full stop.
And that's exactly what I did. I said, listen, you sent me a subpoena for all this information. It's asking for confidential information that I don't think is appropriate. I can't give this information out. Can you please reduce it? That was clearly an objection, or at least I was informing disciplinary counsel that their demands were inappropriate. So when the board said that I did not make an adequately informed them and did not make an objection, that's simply not true when you look at the records. But more importantly, the board also said that I did make other objections, that I made specific objections as to burden, as to overbroadness. And I was saying it was overbroad because they were asking for attorney-client materials in particular that had nothing to do with the overdraft and that would not shed light on how TD Bank erred and caused the check to overdraft my account. So I want to point out with regard to Emory Confidential and the question of whether or not I was supposed to turn over these records. The court just ruled in a case called Emory Paul in 2023. Emory, it doesn't have a citation yet, but Emory Paul, this court found that a lawyer violated 1.6 by turning over client information to disciplinary counsel during a disciplinary counsel investigation. The court said that that lawyer violated 1.6 because he revealed information about his client in filing a bar complaint that was detrimental to her financial interest. Well, that's exactly what disciplinary counsel was asking me to do. Pre-charging me, they sent me a subpoena asking me to provide information about my clients when none of my clients had complained.
My recollection of In re Paul was that in making the initial complaint, the attorney turned over confidential information, that it wasn't in response to a request for records from the ODC. So that strikes me to be an entirely different situation.
The situation was the same as far as I'm concerned, because in both instances, Mr. Paul had two things going on. A complaint had been filed against him, and then he filed a counter complaint against the person who filed the complaint against him. He was responding to the investigation that disciplinary counsel was doing, and he was offensively filing an investigation against the other lawyer. In either event, this was all pre-complaint or pre-charging. It was all part of a disciplinary investigation, and the information was shared with disciplinary counsel. And that's exactly what was going on in my case. Disciplinary counsel was asking me for my client's records, asking me to turn this information over. And in Ray Paul, this court found that that would have been a violation of 1.6.
Paul certainly didn't find that responding to that subpoena would have been a violation. It was in a very different context. For example, it focused on the fact that what was disclosed there was embarrassing to the client and a secret within the meaning of the relevant terms. And none of that
would not revealing the lawyers that I represented, that they sued law firms, that they confidentially settled those law firms with, that still work for those law firms or still work for the agencies that they work for. Would that not be embarrassing?
Well, I have no idea because
that's what they were asking me for. They were asking me to turn over my client's records to explain an overdraft that I didn't cause. Why would a settlement agreement that I negotiated for a client years before this overdraft happened, why would that be relevant to producing? Why would that be relevant to their investigation? It wouldn't be.
It may or may not be true that you would have had attorney-client privilege type arguments with respect to some of what was requested. I find myself a little unclear about how any attorney-client privilege idea would have been a complete defense to failing to turn over much of what was requested. So that I'm much more puzzled by.
If disciplinary counsel has specifically identified the documents that it was requesting, then we could have a conversation about whether or not I was supposed to turn over those particular documents. But as we sit here, as the hearing committee sat and as the board sat, they had no idea what documents disciplinary counsel was asking for. And indeed, the board made no effort, despite my motion to quash, to determine whether or not the subpoena that was issued to me was reasonable under Artis, reasonable under Conning. Those cases say that a subpoena needs to be reasonable. Indeed, the rule that it was issued under, Rule 45, says that an attorney must make an effort to issue a reasonable subpoena. So it doesn't matter what my response was. What matters is, was the subpoena that they issued to me reasonable? And the answer is, it was not. Again, it asked for.
I think we have your point on that. You're well over your time. If you have one last,
I do have one last point.
You'd like to
Disciplinary counsel is suggesting that the hearing committee, which found that I did nothing wrong. They found that I was about to say that they found ultimately that I made a record keeping error. They based that on an absence of evidence. They said that because I had not turned over the records, because they believed that I waited for years to give disciplinary counsel the bank letter, And if you look at the hearing committee, the board, they had to correct the hearing committee's finding. The board said, no, hearing committee, you were incorrect. Mr. Doman turned over the bank letter years before.
I'm afraid you're getting a little bogged down in the sidelight. If you have a point, last point you want to make.
So my point is that there's no basis for any sanction, because the hearing committee found that I had not done anything wrong, and the suggestion that I did is just not supported by the record. Thank you.
Thanks. Thank you to counsel for your briefs and for your arguments today. Before we proceed, and this case is submitted, before we proceed to the third argument, the court is going to take a brief recess, and then we will reconstitute ourselves.
All rise. This court will take a short recess to bring on the next argument. All rise. The honorable court is back in session. Please be seated and come to order.
Morning again. We will hear the third case on this morning's calendar. It is Garner versus University of Texas at Austin et al., number 22 PR 824. And before we get started, I just want to see if I can hear from counsel for appellee if they have reached an agreement about who's going to argue first and who's going to have which amount of time.
We have, Your Honor. We'd like to, first of all, Robert Grant for the University of Texas. Ms. Megan and I talked. We would like to split our time equally if we may, and I'll go first.
Thank you, counsel.
Thank you.
All right, we'll hear now from Ms. Edwards on behalf of Mr. Garner.
Good morning, Your Honors, and may it please the court, Valerie Edwards on behalf of the appellant Patrick Garner. If the court would permit, I would like to reserve 2 minutes for rebuttal. Thank you. This case, Your Honors, presents a very simple, singular issue of law. That issue is whether my client acted within the scope of his authority given to him by his uncle under the durable general power of attorney and his estate plan in amending his uncle's revocable trust to change the contingent remainder beneficiaries as originally named, the appellees in this case in favor of himself. A review of the power of attorney and the estate plan makes it exceptionally clear that my client was authorized specifically and expressly.
Counsel, I don't want to derail you on your progression of your argument, but can we start with the question of the new power of attorney law so that we can kind of have a framework of what we're dealing with here?
Yeah, yes, Your Honor. And to answer Your Honor's question, I wish that it were different, but I don't believe that the law applies to this case. And the reason is very simple. And I'm losing my voice, so I do apologize to everyone. And under section 21-2604.03, subsection 4, the law makes very clear that an act done before the effective date of this chapter, February 23rd, 2023, is not affected by this chapter. And the act at issue is the amendment, which took place on December of 2020. So unfortunately, because I think this law is very helpful in clarifying what the law of this jurisdiction is with regard to fiduciary duties and durable general powers of attorney, especially with regard to changing and preserving estate plans and how family members interact with that process. But I don't believe that it applies to this case. I do, however, think that it is relevant, and I'll discuss that when I get to that point, if the court permits. The lower court of this, or pardon me, the review of the power of attorney and trust in this case expressly authorizes specifically my client to make the amendment that he did without self-dealing. The power of attorney authorized him to exercise the reserved rights to amend the trust and change the ultimate beneficiaries of the trust on behalf of his uncle without limitation, without any restriction, and to fully substitute his judgment. The trust even authorized the successor trustee during periods of the grantor's incapacity to invade the entirety of the principal and the income of the trust, to make gifts to blood relatives without limitation during the incapacity before he passed.
Is without limitation accurate on those gifts? I thought there were some limits imposed on that ability as they related to the attorney in fact, that they could only be for the support of the
Yes.
attorney in fact. So I didn't think it was without limitation.
Yes, Your Honor, you're correct. The attorney in fact has limitations, but we have to remember that my client had two separate roles in this case. He was successor trustee and the trust had certain authorizations, and he was the attorney in fact. And the provision that I am relying upon in this case is within the trust, and it says that during it's Article 5 of his trust, which I believe starts on appendix page 25, and it says during periods of his incapacity, the successor trustee can give unlimited gifts to his blood relatives at the behest of either the attorney in fact, or the successor trustee. And
Would would the authority that creates I'm a little puzzled about the interaction between that provision and the authority provided by it and the limitations on the power of attorney authority. So I'm not sure which would trump which if there were limitations. And I'm not sure resolving this case requires us to solve that mystery, but I'm just letting you know, I'm a little unsure about how those two would interact.
well, I think it is a very important distinction because it goes to what duties were owing at that time by whom. And one of the errors of law of the lower court is that the judge found that my client owed a duty of loyalty to the contingent remainder beneficiaries. And he couldn't have owed a duty under the power of attorney as attorney in fact, because that is essentially a contractual relationship between his uncle and himself. And he didn't owe as
I
a
think I
matter
follow that point, but can I just make sure I understand? Because you use, again, I'm focused on the words without limitation and wondering how unlimited you think the authority of the attorney in fact would be given the language that you're relying on. And so here are a couple of questions I have. Imagine that what your client had done here, instead of what he did do, was he had changed the beneficiaries, not to himself, but to Texas A&M, a big rival of UT Austin, and the Anti-Catholic League, and had said, testified at a hearing, a deposition. I did that because I hated my uncle, and I knew that he'd be turning over in his grave because this is the exact opposite of what he wanted to do with his money, and I thought that'd be hilarious. Would that be fine in your view?
No, Your Honor, and simply stated because under the power of attorney, there were limitations, as you've noted, to what the power of attorney could do. For instance, he couldn't give gifts to himself that would go to.
This is not a gift.
personal
This would be
obligations.
changing beneficiaries.
Changing beneficiaries, correct.
So what's the limit? What would
The limitation on that would also be, and I'm talking about not Article 2, where it talks about the authority to amend.
What Article 3C, I think it is. What I
Article
was-
3C, well,
Of the power of attorney, conduct financial, tax, and estate planning. I thought,
yes, that's under the power of attorney. I do think that there are no limitations to what the attorney in fact could do based off of his authorization to amend the trust
So is your
beneficiaries
answer-
as he would have wanted to do.
so the answer to the hypothetical is relying on that authority. You think that the power of attorney did give your client the authority, would have given your client the authority to do that?
No, Your Honor, it is a bit of a nuance because there is a reasonable expectation. There has to be act within a reasonable expectation and within the good faith duty. And that is outlined pretty nicely in the new law. That is under section.
Well, I'm just a little puzzled because I thought your view about the authority here was that it was absolute and not governed by limitations of the expectations of, the previously expressed intentions of the settler of the trust or good faith obligations. So I'm a little unsure about your answer.
That is my position. My client's position is that the law does not govern. The new law does not govern.
No, it's
because
not
of
about the
that.
new law. I thought I understood your position, leaving aside the new law, to be that this provision in the power of attorney gives completely unrestricted authority on the attorney in fact to amend the trust documents to make anybody the beneficiary for any reason, without any limitation of good faith, without any limitations about self-dealing, without any limitations about previously expressed intentions or expectations of
That
the
is not
settler
my
of the trust.
position. That is not my position. And what I would like to refer to clarify my position is the new law, which I do not believe governs, but which I do think reflects a better clarification of what the law is. And if you look to section 114 as enacted by the DC legislature as 2601.14, that defines particular duties that are mandatory or default. The mandatory cannot be waived. That implies, it does not imply, imposes a good faith obligation. And it says that you have to be acting within the reasonable expectation that you're authorized to do something.
But
But your view is that nothing in the power of attorney would limit the trustee from acting in the way that Judge McLeese has suggested in his hypothetical.
Nothing in the express language of the power of attorney, but it does fall within the common law. And I believe that the new statute is a codification of the common law.
So
I
you're
actually
agreeing
think
that there are some
those are-
common law or restatement provisions that would
That's correct.
apply the same good faith requirement that
You
the new
always
law
have a good
does.
faith requirement to.
So so I would suggest, not to override my colleagues' preference, but that we not focus on the new law, but where you think this external limitation comes from. I mean, it seems like you're agreeing with your colleagues on the other side that there is some sort of common law or restatement limitation on
Yes, Your
unfettered
Honor. And
discretion.
as outlined in the brief, I believe that those are codified in restatement provision 8.06.
But a lot of those provisions seem to say, unless the agreement at issue, and some of it, again, is a little confusing because there are a set of doctrines that apply to trusts.
Yes.
And there are a set of doctrines that apply to someone who has a power of attorney who amends a trust.
Yes.
And so to me, it's less relevant leaving aside the power of attorney, what principles would apply to how you could administer a trust. That's one set of cases that are relevant, but seem to me a little less directly relevant as to what restraints are there on the authority conferred on Mr. Garner as a, I guess, substitute attorney, in fact, under the power of attorney, in exercising the authority explicitly given in the power of attorney to amend the beneficiaries of the trust.
Right, and he has that express authority under the language of the power of attorney. There is no limitation. He says he can substitute his judgment.
Well,
to the
substitute
full-
judgment, as I understand it, isn't so much an untrammeled concept. It's not like I can do whatever I think.
Exactly.
It's more, I can do what I think you would want.
Right,
So
which
that-
goes to
that
your
didn't-
question.
Yeah,
Your
that
Honor.
didn't seem so untrammeled.
Which is why the common law addresses that you have an unwaivable good faith duty. And the reason I'm turning to the new law is because I believe it codifies what the common law was at the time. I believe it codifies even a step above what the common law was at the time. I think the common law was not as detailed in terms of what the requirements were for the expression of authority. I think that what is helpful in section 114 of the uniform law, which is 2601.14, it gives your mandatory duties, which are the good faith, and then it has the default duties, which can be modified by agreement.
So if we assume that there's good faith obligation under either old law or new law, then why isn't it potentially a triable question of fact as to whether or not Mr. Garner was acting in good faith?
Well, I don't think that there is a dispute over this because there's no other evidence in the record to suggest that he was doing anything but acting in good faith. And good faith, as it is defined in this law, as it is reflected in the new law, which does not apply, but I think does reflect the codification of the common law, is honesty in fact.
And so am I right that your position then is that there is some good faith requirement imposed by common law, but the difference between Judge McLeese's hypothetical with respect to Texas A&M and here is simply that I think in Judge McLeese's hypothetical, there was factual evidence that he was aware or that he was expressly doing this contrary to his uncle's wishes. Is that the difference?
There is no factual evidence to that effect.
No, in the hypothetical.
Oh, in the hypothetical, correct.
And are you
There's
saying
no
that that's the
reasonable
difference between, because here he changed the beneficiaries to himself. In Judge McLeese's hypothetical, he changed the beneficiary to Texas A&M and so on.
Yes, Your Honor.
What's the difference other than in the hypothetical, we assumed evidence that he was doing that specifically to contravene his uncle's wishes. Is that what you're saying the difference is?
It is, and it is codified in the new law, which is a reflection of the old common law under 2601.14A under the mandatory duties. A1 says you must act in accordance with the principle's reasonable expectation to the extent they're actually known by the agent. And so in that hypothetical, he would have actually known that there is no way his uncle would have wanted to do
Well,
that.
so what
That
about a
would be
different hypothetical where instead of giving this money to the UT library, Mr. Garner gives it to the Texas A&M library because he's a proud Texas A&M alum and thinks their library needs it more?
That actually gets to a different question, which is whether or not he had authority as the trust. I think we're talking about the power of attorney, but as it does go back to his authority as the successor trustee as well, where he could identify who is the proper charity here. And what if the charity didn't exist anymore? There are tons of doctrine in trust administration that address how somebody is authorized to best serve the wishes of the decedent in that case.
Well,
And if he had a reasonable expectation.
I think some of these questions are going to working out the implications of what to me at least is a new understanding of the position you're taking that does wrap in a good faith requirement, and trying to figure out kind of what the scope of it is, but also why that isn't factual and why we can be sure that whatever its contours are, which I'm not sure of, that, you know, as a matter of law, those contours were met. And so just to make sure I understand, first, like, could you just say a little bit more about what you think the common law good faith obligation entails? You said some things about what the is this a fair paraphrase of what you're getting at? And if not, can you give me a better one? That the attorney, in fact, exercising what's on its face seems to be unlimited authority to designate any beneficiary, has to do so acting in good faith,
Yes.
and that means ... in a reasonable effort to conform to the wishes of the settler.
At least not to defy it. The code does say, in the new iteration of the code, it does say act in accordance with the principal's reasonable expectations to the extent actually known and otherwise in the principal's best interest. And it defines best interest only to pertain to the principal, not to any.
Why isn't the best evidence here of that what was in the unamended trust document as to what I mean, we don't have any evidence that there was any other purpose.
Well, there is actually other evidence, and it's uncontroverted. My client testified in his deposition that at the time the decedent made his power of attorney and made his estate plan, his intent was to disinherit his only brother who survived him, with whom he was estranged. And so he did not want to provide for his only heir at law. He and his nieces and nephews at the time were too young to inherit
But that was speculation, right? I mean, he didn't say that he had actually heard that from his uncle.
Well, it's corroborated by the relationship that was maintained and
and relatedly, I mean, if that's a factual question, there may be some evidence relating to it, but the trial court, I mean, the parties, I think, moved for cross summary judgment. Nobody thought there were disputes of fact, in part maybe because I'm not sure the legal positions were as I'm now understanding them. So nobody's made any finding about that or a determination that there's no material dispute of fact with respect to that.
I do think it gets back to the other provision in the trust, which allows the successor trustee to invade the entire trust and give it away as gifts in the period of the decedent's incapacity without limitation, but only to his blood relatives.
Can I ask you another hypothetical? And you may have the same answer. Another thing I was wondering about is if your client, Mr. Garner, not the decedent Mr. Garner, but your client, Mr. Garner, had not been able to assume the duties of attorney, in fact, I think that SunTrust Bank or some bank would have been the next in line.
Yes.
And if they had, what would their ability have been to amend the? I mean, at the most extreme, could they have said, well, we'd like $3 million and it's not self-dealing under the terms of this agreement, so we're just going to give ourselves the $3 million. I assume you think that can't be done.
Well, I think that there are boundaries to corporate trustee fiduciary duties. I think there is
extrinsic. I leave aside for a
yes.
minute what extrinsic principles of law, but just as a matter of interpreting these documents in the first instance, you would say, if I understand your position, if you look at the face of the power of attorney document, you read it as authorizing that. And if there's a limit in doing that, it's extrinsic to that and is imposed by common law or maybe
Yes.
special doctrines that relate to corporate trustees of the like.
Yes, and there is a distinction under the new law that is important that differentiates descendants and family members and gives them, it better defines the fiduciary relationship with the durable general power of attorney that is exercised by a family relative, a spouse, an ancestor, or a descendant. And it says that those persons are by implication permitted to benefit without the same limitations that a non-descendant, non-spouse, non-ancestral relative
So here's
would have.
I still, in part because I don't think the case was fully presented this way. I don't have a good sense of your view of what the source and scope is of the good faith, kind of the extrinsically imposed good faith limitation. Let me ask another hypothetical to see if I can get any sense of
Yes.
kind of roughly where you would be on it. Imagine that the beneficiaries here, instead of having been charitable, had been Mr. Garner and all of his other surviving cousins on an equal basis. And imagine that had been the beneficiaries, and imagine then he looks at the trust documents and the power of attorney documents and says, well, you know, I have the power to make myself the sole beneficiary, and I'm going to do that.
Well,
Would you say that would have been within his authority or outside his authority, or a question of fact for a fact finder to determine whether or not it would be within his authority?
I think that is squarely a question of fact, because there are other incidents of evidence in the record here where the decedent did intend to benefit his blood relatives and his nieces and nephews. There's also evidence that he saved all of the cards, the greeting cards and correspondence with them over the years.
And I guess that position seems to me to arguably imply that the propriety of what was done here is a question of fact. Because if I get your point that if there is a good, what I take to be a line of your thinking, which is if there's a good faith obligation here, it's pretty comfortably fitting within it to give money to, instead of charitable beneficiaries, to blood relatives. The documents authorize that in various respects in various ways. But if it's right that, so that's kind of step A, but then the question is, okay, so that's, he could throw the charitable beneficiaries out the window, and that wouldn't necessarily be bad faith. I get that line of thought. But then the question is, he ended up settling only on himself, not also his other cousins. And if it would be bad faith for him to have changed the document that said that to only himself, then why isn't it bad faith for him to pick that option in amending a document that said something different?
Well, I didn't say it would be bad faith.
No, it would be a question of fact. You're quite
Yes.
right. I apologize. I went beyond what you said. But why wouldn't it be a question of fact here too, whether what he did in designating himself rather than his other cousins as well as beneficiaries was or was not bad faith relative to this extrinsic doctrine of good faith that you are acknowledging applies?
Well, I don't think it would be bad faith, but I do think it would be a question of fact. And again, there were there was evidence in the record that showed that he maintained a relationship and wanted to benefit his blood descendants.
To be clear, my question got very convoluted, so let me try it again in a simple way. Why isn't it a question of fact in this case?
Because
Whether Mr. Your client, Mr. Garner's designating only himself rather than also his other equally related cousins was bad faith relative to the good faith doctrine that you acknowledge exists. Why isn't that an issue of fact in this case?
Well, I think that is beyond the scope of the record in this case, first of all, but also he was authorized under these documents to have a general power of appointment. So he could designate himself and then divvy it up with his family as much as he'd want to. But then that again is outside the scope of the record.
Well, okay, but I mean, it seems like you're, again, putting aside that both parties agreed that this was resolvable on summary judgment, but is your, I mean, let's assume that the record is neutral or non-existent on indications from Mr. Garner one way or the other than obviously who he had already designated as beneficiaries in the trust, and devoid of any record evidence that your client, Mr. Garner, knew of anything one way or the other. Are you saying that level of equipoise or absence of any evidence, in other words, the burden fell on the beneficiaries to show that in seeking summary, well, I mean, not in seeking summary judgment, but if there were a factual question, that the burden would be on the beneficiaries to show that?
100%. And they presented no evidence that Mr. Garner, the decedent, had maintained any relationship, donor-wise or otherwise, other than just, I guess, the affection that he said in his estate plan 20 years ago, with the caveat that at any point he could change those beneficiaries under Article 2 of his trust, and authorized his trustee to invade the entire principal so there could be nothing left for them at the end of the day, and gave his attorney, in fact, full authority to act on his behalf in those two capacities. So yes.
But you would agree then that if, and obviously I'm not saying you're saying this, if there was some letter that had been uncovered during discovery in which Elder Mr. Garner said, do not change these beneficiaries,
Yes.
or I only want these to go to these four entities, that your client would have lost as a factual matter under this good faith analysis? I mean, potentially would have lost.
I think it would have been a factual question on the good faith issue. It depends on when that letter was written, all sorts of different factual questions. But there was nothing in the record. There were no letters or correspondence. There was no notification to the charitable beneficiaries that they had been named as beneficiaries. They were unaware until my client, in good faith, transparency, named them and brought this action.
I thought he was initially didn't name them and then was required
Yeah.
by the trial court to name them. So
No, Your Honor, that was in the probate petition just to admit the will. This was a separate
right, but my
proceeding.
point is, I thought timing wise, they were aware, they became aware of their status in
in the
virtue of a
probate.
requirement by the trial court in the probate matter.
In the probate matter, that's correct, just to get it opened to begin this entire thing. But my client had full intention to bring this case at the recommendation of counsel.
Can I ask an antecedent factual question? Everyone seems to accept that Elder Mr. Garner was incapacitated, I think. Everyone also seems to acknowledge in their briefs that there was no adjudication of that. I did see in the record two seemingly compliant forms by physicians. Is it well accepted here that he was officially deemed incapacitated? Or-
Yeah, yes.
I mean,
Your
I'll
Honor.
ask your colleagues on the other side that question.
My
too.
understanding is that's been conceded entirely. He was in a very bad state, institutionalized with.
Right, but I guess, I mean, we can all know that, but under the legal requirements, do we know that?
We know that there was a proceeding, an adult intervention proceeding brought by the hospital when he was admitted which instituted this entire thing. And that's what unearthed his estate plan. And that is when my client was contacted and said that the estate plan shows a strong preference that there not be a court-appointed conservator or guardian, and that you serve in this role as successor trustee and make sure that his medical and financial needs are taken care of. So that is how he assumed that role. And there's testimony from my client that cannot be controverted, that he was incapable of having conversations, and he passed away only a few months later.
I know we're over time, but just to make sure, to the extent your position is that there are extrinsic principles of law, not the new statute, because in your view, it's not directly applicable, but the new statute provides analogies or support for what those extrinsic obligations are. And you're not, I think, pointing to cases of this court that shed light on what the limitations are on the powers of attorney. We don't really seem to have much on that I was able to find, or that the parties have presented to us. So you're instead looking, I guess, at restatement principles and maybe cases around the country. And if you're going to be if you're pointing us like what provision of which restatement do you think we should be looking at as the source of this extrinsic good faith obligation that is an overlay that constrains the otherwise arguably pretty untrammeled authority of the power of attorney? Which provision of which restatement are you focusing on?
I'm focusing on the 8.06 of the restatement of agency. And I believe I also cited section 78, which involves transactions. So it's a little bit of an ancillary.
And 78 on in the restatement of trusts.
Yes, no.
Is that also agency?
Yes. If you'll,
No,
and I will address this in my rebuttal as well, but I also, as much as no one wants me to talk about the new law, it is very important because in that same 114 section, subsection A6 provides as a default modifiable duty, the duty to preserve someone's estate plan. And it does address an estate plan beyond just the context of the dispositive provisions. In fact, it focuses mainly on the provisions to take care of the physical and financial needs of the grantor of the trust.
I'm sorry, I think I missed that. So if we think that the new law applies, do you think that under point 14, I guess it's B6, that your client would have had to have maintained the beneficiaries as they were in the original estate plan?
No, Your Honor, not at all. Subsection 6 says that there's a duty to attempt to preserve the principal's estate plan to the extent actually known by the agent if preserving the plan is consistent with the principal's best interest based on all of the relevant factors. And that sets forth best interests, which talk about the physical and financial needs of the grantor, not the the interests of the contingent remainder beneficiaries, which I think is one of the errors in the lower court focusing on, a breach of duty owing to them where one did not exist.
What about the preserve the principal's estate plan, right? That's sort of the obligation of honoring what the principal wanted as opposed to any sort of relationship to the contingent beneficiaries.
Well, you have to remember in this case that his estate plan was not in all circumstances, I want to provide for these charitable beneficiaries. His estate plan said, I could change my mind at any time, and I'm authorizing my attorney in fact to make those changes and exercise that right to amend those beneficiaries at any time. So there was never a reasonable expectation of the agent, in this case, my client, to under no circumstances change this.
It gets a little circular though, because if you think the estate plan is let the attorney in fact do whatever the attorney in fact later decides to do, then you preserve that plan by letting the attorney in fact do
Yes.
whatever the attorney in fact wants to do without
That's
regard
correct.
to the intent of the beneficiary.
That's correct. The preserving the estate plan does not mean preserving the designation of beneficiaries and the dispositive provisions. Preserving the estate plan is far broader than that. It is, who do I trust to execute this? How do I want them to execute it? What do I want during my periods of incapacity, during my lifetime? How do I want my affairs dealt with after my death? So it is
Okay.
not specifically.
I got that thought. I mean, again, so I'm still struggling to make sure I understand your position. Is this a fair characterization of an aspect of your position? Although the new law doesn't apply, you are willing to acknowledge that in determining the legality of what was done here under the common law principles that preceded it, if we determine that the new law would have forbidden this, it would be appropriate for us to determine that it is not permissible. And conversely, that if we concluded that the new law would have authorized this, you think we should end up saying that the common law would also have done the same?
Yes, Your Honor. I think actually the only difference here with this new law is it goes for the first time in DC code history, it identifies the ability to make changes to the ultimate beneficiaries of an estate plan, which was not addressed in section or Title 19, and it was not addressed under the repealed Title 21 with the prior statutory durable general power of attorney. And that's why we go through this whole weave of the restatement and the different principles of general power of appointment that were existing under the common law in our brief.
Thank
Thank
you.
you.
We will give you a couple of minutes in rebuttal, and we'll hear now, I think, first from Mr. Grant.
Thank you, Your Honor.
Thank you, Your Honor. May it please the court, Robert Grant on behalf of the University of Texas. So I'll dive right in with Judge Shanker's sort of framing question and where I think you ended up, Judge McLeese. We also agree that the new act does not apply here because of subsection 4, where we're evaluating an act that occurred before the effective date of the statute. We also agree that the act
Could I
isn't
just
really
stop?
modifying District of Columbia.
What is the act? Is the act the redesignation of beneficiaries?
I'm sorry, I was referring to the Power of Attorney Act. So we agree that the new Uniform Power of Attorney Act does not apply here.
I think she means
Because-
the act
Sorry, the
act
act,
under
the
section
act in
4.
question or transaction in question is the amendment itself. So because the amendment occurred, sorry for misunderstanding the court's question, because the amendment occurred before the effective date of the new statute, we believe the new statute doesn't apply to the analysis. But we also agree with the appellant that the new statute is really a codification of existing law rather than a modification of existing law of agency, specifically agency under powers of attorney, where I guess we part company with the appellant is our conviction that if the new acts did apply, that it would clearly prohibit the conduct at issue here. And that's, again, because of the same subsection that counsel alluded to, 21-2601-14, subpart A, those duties apply notwithstanding any provision in the power of attorney purporting to waive those duties or eliminate those duties or excuse the agent from complying with those duties. These are all common law duties to act in accordance with the principal's reasonable expectation to the extent actually known.
So counsel, sorry to cut you off, but you seemed in your brief to rely more. I'm not saying you didn't rely on common law or restatement notions, but you relied much more on the text of the contract and specifically Article 4 of the power of attorney and its best interests requirement, which related to transactions. Are you veering from that now and saying that there are these extra contract limitations on what was done here, or are you adhering to or which argument really, or both?
It's really both. Article 4 contains a limitation which would prohibit this change of beneficiaries because it requires that transactions be undertaken consistent with the best interests.
And you think this amending the beneficiaries is a transaction?
I think you have to rely on an overly narrow reading of the word transaction to say that this action taken under the power of attorney is not a quote unquote transaction. I think so we believe Article 4 applies. We believe and have argued below that there's also sort of a bedrock. It's not even a duty. I mean, when you create a principal and agency relationship, when you execute a power of attorney, you're authorizing someone to act in your stead. And so it's an impossibility for the agent to act in a way that's not consistent with
Right, but sorry.
So as I read Article 4, it's an exemption from liability, meaning that you couldn't turn around and sue Mr. Garner, but here Mr. Garner has brought the declaratory judgment action. And so I'm wondering, to what extent does Article 4 have any force?
Well, it does, we would argue, sort of specifically import into the power of attorney this obligation to act in good faith and consistent with the principal's best interest. You could
bring an action now saying that Mr. Garner, in changing beneficiaries and depriving you of what you thought was yours, was not acting in good faith, right? But I don't think you can use Article 4 as kind of a shield in this proceeding when you're not seeking liability.
We aren't seeking liability. I think the question is really, what is the force and effect of the amendment itself? In other words, we're not saying that it should be set aside based on a breach of fiduciary duty or something. We're saying that it should be set aside as a nullity because it was outside the scope of the agent's authority. So in that regard,
seems to be, and I ran across this principle too, almost that the whole thing is a nullity, at least if read as I originally thought that your opponent might be reading it, which is the attorney in fact was free to do whatever the attorney in fact wanted without limitation as to who the beneficiary was. Because you made the point, which there is at least some support for, not so much in our cases, but around in sources outside of that, that's just not a cognizable form of, that doesn't create an agency principle. That's not agency. You can't say, I'm your principal, you're my agent, you do whatever you want.
Right.
That's just not agency. And then I guess something that purported to make you my agent, if I had an agreement that said that, just would be maybe invalid as not agency, or I don't know what it's, what is it? If it's not agency, then is it invalid or is it just not agency?
It's both. It's not an act within the scope of his authority as agent, and therefore the amendment itself is invalid. It's a nullity. It's a little bit like the concept.
I guess I just, if I get the idea that that's not understood as agency. It just wasn't so clear to me on not looking very far into it, that means that's not a thing that one can do in a legally enforceable way. It's nothing. It's just completely invalid. If I say, I own a property and here's what I authorize you to do, whatever you want with the property. Well, that's not an agency relationship. I'm just telling you, you can do whatever you want with the property. Why is that not enforceable? It's not agency, but is it somehow not enforceable?
Well, it's not enforceable because I don't know in your hypothetical in what format you would do that. If you gave someone a deed that said, do whatever you want with the property, it's yours, that would be one thing. But if that language is in a power of attorney, then you're situating it in the context of a document that creates by its nature an agency relationship.
So
But-
it sounds like your answer might or might not be invalid, completely void, depending on its context. But if someone purported to make it a power of attorney, then it's invalid if people are trying to make it that. Is that a fair description of what you're saying, or am I missing your point?
I think that's a fair description of it. I mean, we're talking, the authority to make the amendment in question comes from a power of attorney document. And they say that the appellant says, among other things, that it authorized him to make this amendment. And our argument is, look, this isn't at bottom, it's an agency relationship. And you can't authorize the agent to do something that is not in your own best interest, nor do I think there's any indication either from the text of the power of attorney itself or anywhere else in the record that that's what Michael Garner was attempting to do when he executed this power. I mean, it's always subject to this good faith requirement. And that's what the new statute does clarify, codify.
Can
But
I
that's,
see if this way of potentially simplifying the case works from your side? I know it seems like you have a separate argument, which is whatever extrinsic principles may come into play. If you just look at the document itself, the power of attorney, read appropriately, in part the word transaction as you construe it, but in part other references to in behalf and other, pieces of it, read it as a whole, it itself imposes a good faith obligation with respect to that. I took to be one of your arguments.
yes.
It sounds like a second argument is there are extrinsic principles that also would require good faith, even if the document clearly said, but there's no requirement here. Imagine Mr. Garner had amended, well, this is a power of attorney document, so never mind. Imagine that the power of attorney said there is no good faith obligation to do anything relative to the interests of the principal. The attorney in fact can do whatever the attorney in fact wants. You would say, well, you wouldn't have your argument about interpreting the document necessarily, but you would still have your extrinsic source of authority. With respect to the extrinsic source of authority doctrine, nobody has really pointed to case law in this jurisdiction that tells you what the scope of that obligation is. There seems to be agreement there is an obligation. There seems to be agreement that the scope of that obligation is accurately captured by the provisions of the new law, even though there's agreement that the new law itself does not apply of its own force. So is it fair to say that at both sides, from your perspective, it's fair to say from your side, that in figuring out your claim that there are extrinsic principles of law that require good faith exercise of the authority conferred by the power of attorney, you are fine with us determining that by looking and interpreting as best we can the new law. And if we think you win under that, then fine with respect to that argument. If we think you lose, then we might be wrong in your view, but we've looked to the right, appropriate source of illumination. And then you'd have your separate argument. Or do you want us to be not so tied to construing our pre-existing law by taking as a given that both parties agree that the new statute, though not directly applicable, accurately captures those extrinsic principles?
I think my answer to your question is yes.
My question was so confusing. I don't even know if that's my fault.
No, that's okay. Our position is that the new law does codify longstanding hallowed principles of agency law, and that good faith requirement is baked in there. I didn't quite come up with the A&M hypothetical that Your Honor did earlier, but I was thinking of another hypothetical where, and I think it's important to remember when construing this power of attorney was effective immediately upon execution. So let's say that Patrick, and I don't mean any disrespect, but we have two Mr. Garners. Let's say that Patrick learns of the existence of the power of attorney in 2003, and he reads it and he says, I'm allowed to substitute my judgment for my Uncle Michael's. I think I should be the beneficiary during his lifetime. Forget about a post-death change in the remainder beneficiary. I want to be the income beneficiary. And so he does an amendment and he sends a letter and he says, "Dear Uncle Mike, you should know that exercising my power my authority under the power of attorney, I've changed the income beneficiary and I want you to start sending me checks. I don't think that even the appellant would argue that that was a permissible exercise of his authority, but why not? I mean, it's effective, the power is effective immediately upon execution.
In your hypothetical, not in this case. In this case, it was only effective upon incapacitation. Is that right?
No, it's effective upon execution, Your Honor.
Oh.
So immediately in 2001, when Michael signs this POA, it's effective. So under what I thought the appellant was arguing, arguably, Michael could have said, okay, it's effective immediately upon execution. It authorizes me to do estate planning. It authorizes me, as I read it, to change the beneficiaries. It authorizes me to substitute my judgment for Michael's in doing estate planning. So I think I'm a better beneficiary even during his lifetime than he is, so I'm changing it. That would be absurd. And the reason it would be absurd is because at the end of the day, he's an agent. He has to act on his uncle's behalf, in his uncle's best interest.
Right, but I mean, it's an egregious example, but it still begs the question, right? Because I mean, your argument seems to prove too much, because anytime a trust document names beneficiaries and someone is authorized to change them, then they will and there's no external evidence one way or the other, let's say, then they will necessarily be contravening the expressed interests of the trustor. And so at what level, why should we be getting into whether they are changing it to a good thing or a bad thing versus whether they were allowed to change it? And just the mere fact that they're changing it from what the trustor had expressed cannot itself be evidence that it was done in bad faith.
Let me dodge your question a little bit, but I think there are two answers to it. First of all, is this concept that I think Judge McLeish, you had asked about earlier, of substituting judgment. That's a term of art in this arena, okay? In fact, the guardianship statute, and this is DC Code 21-2011 in the definitions section in 25A, defines substituted judgment. It reads, substituted judgment means making a decision that conforms as closely as possible with the decision that the individual would have made based upon the knowledge of the beliefs, values, and preferences of the individual. So a decision that conforms as closely as possible with the decision that the individual would have made.
Now
That's the guardianship statute.
Not directly applicable to interpreting the statutory, the power of attorney phrase. But
I'm not saying it controls, but that's an example of what we mean when we talk about substituted judgment in this context. And it does go to it's analogous to, I would argue, the sort of reasonable expectations language in the new act. Now that I've started to dodge your question, let me see if I can address it more directly. Obviously, and I think you asked this earlier, the best evidence of the intentions that the decedent had about the beneficiary are to be found in the trust instrument itself. That's sort of a bedrock principle of trust interpretation. But obviously things can change. And what the power of attorney is doing, what a properly drafted one is supposed to be doing, is empowering the agent to act in situations where things might have changed and when there might be legitimate reasons.
But that's not what the power of attorney says. The power of attorney says you have the authority to make any decision whatsoever without limitation with respect to any trust.
Well, it says that in one place, but then there are all sorts of other limitations, and it talks about estate planning. And without getting too far afield, I mean, estate planning, when new clients come in and we talk to them about what does it mean to say you're hiring us to do your estate planning, we're talking about doing a set of documents that get their assets from point A, that is their ownership, after their death, to point B being where they want them to go. So even to say, I'm empowering him to make decisions in my estate planning, there's still this idea that they have to be decisions that Michael would have made or that are consistent with his reasonable expectations.
But how do we know?
So there is a situation, you asked, I think, during appellant counsel's presentation, what if he had found a letter, so Patrick gets word that Michael's in the hospital. hasn't talked to him for over a decade, comes to DC, says, okay, I've learned that I'm the trustee, I'm the agent under the power of attorney, I got to figure out what's going on here. I go through his papers and I find a letter, but instead of what, and I know your hypothetical, this is why I said I'm dodging your question a little bit, your hypothetical was there's no indication of any reason for a change. But what if the hypothetical were that he finds a letter that Michael has written but not sent, saying, Patrick, I'm changing my trust and I'm making you the beneficiary. Or Michael meets with an attorney, Patrick meets with an attorney who says, I was working with your uncle, we were coming up with a new draft, he was going to change everything and he was going to make you the beneficiary. Texas is out, the Catholic entities are out, it's all going to you. Then I think Michael could have said, okay, the power of attorney is effective immediately. I'm authorized to do estate planning for my uncle. Now I have some good faith basis to believe that he wanted to make a change. So I, acting within the scope of the authority and consistent with the obligation of good faith, consistent with what I understand to be Michael's reasonable expectations, now I can amend the
But so now
trust.
we're just talking about when it comes to a factual question, really, who on good faith, who has the burden? And I mean, because I asked your colleague on the other side that same question. And it seems like here we all agree we don't have that letter in either direction, right?
Right.
And so it seems to go back to my original question that you seem to be saying that when that's all we have, that the mere fact of changing the beneficiaries is evidence that you're contravening the trustor's interests, which doesn't seem like it can be.
That's not exactly what I'm arguing, Your Honor. I would say the trust is the best expression of who the settlor wanted the beneficiaries to be. So unless there is something to indicate that he changed his mind, I mean, he had 20 years to change his mind about who he wanted the beneficiaries to be. He didn't. There's no evidence. So if we're thinking about, what evidence might have been presented to the trial court.
I mean, that sounds, the way you're phrasing it, that just sounds like a burden shifting idea, which is to say, if you are, the way you framed it is, we have a document that has a disposition, has beneficiaries in it. And and maybe generally, or at least perhaps when there's self-dealing in the picture, what would normally be called self-dealing, even if the power of attorney appears to authorize it, maybe your doctrine is narrower than that. Your view is, if you are a beneficiary, if you are have a power of attorney and you change what's in that document, and someone accuses you of doing it in bad faith, you better pony up with something that explains why that's legit. And if you don't, you are, at least you're subject to a jury trial or a trial in front of a fact finder about bad faith or not. And is that your position, or that's what it sounded
Not
like?
exact. I mean, I don't think that's an unfair position. I think as an agent, you're a fiduciary and you have to justify your conduct. This comes up certainly in the guardianship realm. It comes up with trustees all the time. To situate it more precisely, though, just in the context of we're trying a case, I would say that, and the case, the issue is this amendment valid or not? I would say, okay, and let's imagine, first of all, it's a declaratory judgment action. So we have to think of the burden of proof. It gets a little screwy anyway, but let's say that University of Texas files suit to invalidate the amendment on the ground that it exceeded his authority inside the power of attorney. And so as the plaintiff, we have the burden of proving that it was invalid. We would say that we had met our burden of production by showing the trust instrument and saying, he signed this, he said he wanted it to go to Texas and to the Catholic entities, and he never, over the course of these many years, changed it.
It's kind of academic, though, because there was, whether people were really zeroed in on this in this way in the trial court is unclear to me, but there was other evidence, some of it from the deposition of client, Mr. Garner, about the extent to which they're bonds of affection or were not bonds of affection. And all of that would be potentially relevant to whether the change in beneficiary from your client and your colleagues' clients to Mr. Client, Mr. Garner, would be in good faith or bad faith or consistent with the expectation. So there was other information, not just the designation. And some of client Mr. Garner's deposition testimony seemed to be, as his attorney here has tried to advocate, to support the idea that really it would be consistent with some of the lines of thinking that there's some evidence about to change the beneficiary to her client. And then some of it seemed like it would maybe point the different way, which makes it seem like, although the parties did present the matter on cross motions for summary judgment, that there might have been a triable question of fact here. If the issue is really was what was done here good faith, if that means consistent with the reasonable expectations of the settler, I mean, it seems like, that would be a good question for a fact finder, having read and taking different reactions to the original documents, the powers of attorney that were executed, and then the other information that came out primarily, I think, through the deposition of client Mr. Garner, which has pieces that seem to point in both directions.
Yeah, I would say, Your Honor, that there's really, frankly, a dearth of any factual evidence one way or another. I mean, the bonds of affection, will stipulate he loved his nieces and nephews. He kept the cards. We're not disputing any of that.
Well, but the document itself also seems to, in various ways, including in the transaction parts of it, contemplate the idea that his descendants might well be beneficiaries or recipients of gifts or the like. So the document, if you look at the document itself, it has materials in it that if I were arguing to a fact finder, don't take this as a document. This is not a case like the one hypothesized where you look at the original document and it's like all UT and all the Catholic related charities. It has parts in it where it clearly contemplates the possibility of and is open to assets of the trust being devoted to descendants, including Mr. Garner in particular. And so it seems like that would be another piece of evidence that one could take into account to support a factual determination unfavorable to your client.
And actually, if I could just piggyback on that, is I think your opponent or colleague on the other side argued that the face of the document itself is evidence of the bonds of affection, in that he gave virtually unfettered discretion to this very nephew in the first place.
Though I would have fun at argument saying, and apparently he also really loves Sunbank Trust because he gave that power to them too in default.
Fair enough.
Right. So first of all, the documents do refer to descendants. Patrick is not a descendant of Michael's. When the appellant argues this in the brief, they use the term collateral descendants, which first of all does not appear in any of the documents. And it's a little to me like jumbo shrimp. I mean, a descendant is a child, a grandchild, etc.
Fair enough point.
Collateral descendant, I suppose, includes nieces and nephews. He didn't make a change to include any other nieces and nephews. He only made it to include himself. Judge Schenker, to your question, I would say, he's doing this document. He has no children of his own. He had to name an agent, and he picked his nephew, who I guess in 2001 he thought he was closest to, was most trustworthy, was a lawyer. I don't know why. No, I don't think anyone knows why he picked Patrick at the time.
I don't think he was a lawyer yet, but
he might not have been a lawyer at that point. I mean, we can infer something maybe about that being a bond of affection, but I think respectfully, that's a bit of a stretch just based on the fact of being designated as an agent in the document.
So can I ask, is the upshot of your argument on this piece of it that although the trial court didn't really so much go through this exercise, if we take as now undisputed between the parties, that the question here is whether the power exercised here was exercised in good faith, as it would be reflected. A question here, not the only one necessarily, but a question here is whether the power exercised here was exercised in good faith, as that might be informed by the new power of attorney statute in DC, that no reasonable fact finder could conclude anything from the factual materials touching on that were in front of the trial court, other than that it was not in good faith so defined, and therefore that you're entitled to prevail as a matter of law, if that's the issue. Is that what you're arguing essentially?
Well, the standard, excuse me if I may, Your Honor, we cited on page 30 of our brief with a quote from 6921 Georgia Avenue Northwest, which is 954 Atlantic 2nd, 967 at 971. Trial court's finding of bad faith is a factual one, which this court reviews under the clearly erroneous standard. Now, there was no.
So you think that the trial court didn't really grant summary judgment? The trial court essentially had a trial on this factual question.
Well,
We've already had a trial.
I think the undisputed facts support a finding of bad faith for two reasons. One, an appellant sort of critiques the trial court for this focus in the brief on the lack of a discussion between Michael and Patrick. And I would agree. I mean, obviously, the point of the power of attorney is to empower someone to act even when no discussion is possible. That's why we call it a durable power of attorney. But what the trial court, I think, was getting at there in that portion of its order, and it did examine the undisputed facts in detail, what the trial court was saying was, okay, what's the reason for this change? Michael's in the hospital. There wasn't, I don't think, a formal adjudication of incapacity, but it's undisputed that he was essentially uncommunicative in the hospital. Patrick has maybe kept in touch with him on a very periodic basis, birthdays, something like that, but really has not spent any meaningful time with him for over a decade. He doesn't know he's in the hospital until the guardianship proceeding has cranked along long enough that they find Patrick in Texas, and they find the power of attorney, and they say, you got to get up here, your uncle is in the hospital. So there's no discussion that's possible because Michael is uncommunicative at this point. And there is no letter on the desk, there's no draft amendment, there's no conversation with estate planning counsel to suggest a motive for the change.
I get your marshaling of the facts, but where I get me confused is to say that on summary judgment, the trial court made a finding of fact that is entitled to deference, as whether it's clearly erroneous or not. I mean, trial courts don't find facts on summary judgment that other people defer to. They may determine that there is no material dispute of fact, or no fact finder could just resolve a matter one way or another. So that's why I'm still a little confused about your suggestion that we should be deferring to some factual finding the trial court made, because unless the trial court permissibly did something beyond what I'm familiar with from normal summary judgment, there isn't a factual finding here for us to defer to.
Well, maybe that is then the argument that no reasonable fact finder could have concluded otherwise on the undisputed facts. The other thing that I would just note,
you're well over time and you have a colleague. So if you have a quick point you want to wrap up with, unless my colleagues have further questions, but I do want to make sure we keep
just to wrap up on the good faith point, and I appreciate the court's indulgence. I think the new statute did cause us to take a little more time than we otherwise might have. But on the bad faith point, just one other fact that was in the record, and I think the trial court made note of it. Patrick, when he got up here, hired counsel. He hired Ms. Edwards' firm to advise him about what he was supposed to be doing as successor trustee, as agent under the attorney in fact. He didn't tell them about the amendment. He did the amendment on his own without informing them. And then, as Ms. Edwards said in her presentation, it was on her advice that he brought the proceeding to say, okay, is this amendment valid or not? The court didn't make a specific, the court referred to that fact. It didn't make a specific comment on it, but what I suspect was going on in the mind of the trial court was the sense that if he were really acting in good faith, he had counsel, he could have asked is this something I should do? Or he could have said, heads up, I'm doing this, and he didn't. Even in the sort of relaxed conception of good faith, as was he acting in a good faith belief that he had the authority to do this, there's a basis for the trial court's finding that he was acting in bad faith.
If we
Thank
think
you.
that that was not a finding for the trial court to make, would you resist a remand for a finder of fact to determine whether this was good faith?
I'm not inviting the court to remand. I think the court got it right based on the undisputed facts. But I don't disagree with the concepts that you're raising.
I
But
would rather have that than outright reversal.
yes, please. Our position is that the trial court got it right and that it's a remand isn't necessary. Thank you.
Thank you, counsel. We are now from Ms. Megan.
May it please the court, Heather Megan on behalf of the Catholic entities who were named as the charitable beneficiaries of the John Michael Garner Trust. I agree with my colleagues about the application or non-application of the Uniform Power of Attorney Act. But there is also the Uniform Trust Act, which we haven't really talked about that much today, which I think the court should also look at when looking at the duties that Patrick Garner had with respect to exercising the attempted amendment and changing the ultimate beneficiaries after his uncle died. There is case law in the District of Columbia that says that when looking at a trust and looking at the settler's intent, this is a case that was not cited in our brief. It's In Re Durasco Marital Trust, 862 Atlantic 2nd, 914. It's a 2004 case, which said that the court should look at the language of the instrument as a whole rather than isolated passages. I think that concept will help evaluate the issues that we're talking about today with respect to how the power of attorney and the trust correspond to each other, and what were the duties that Patrick Garner owed to his uncle, who is not only the principal under the power of attorney, but the settler of the trust. And so with respect to the duties, when you look at the Uniform Trust Code 19-308.02, it's called duty of loyalty. And in subsection A trustee shall administer the trust solely in the interests of the beneficiaries. And so when you look at that particular code section, it makes it clear that everything that Patrick Garner does as a trust or affecting the trust needs to be in the best interest or in the interest of the beneficiaries.
But they're not beneficiaries yet,
But his
right?
uncle was, right? So his uncle
Right.
is the beneficiary, and his uncle clearly specified that when he died, that the ultimate beneficiaries, the remainder beneficiaries, are the charitable institution.
So then your argument would have to be that there is no permissible amendment to the beneficiaries of a trust by an agent.
Well, that's not. So let me give you a couple of examples of what would be. So let's say that John Michael Garner had millions and millions of dollars, and as part of his estate plan, his tax advisors have said, why don't you start gifting some money to get under an estate tax exemption? And so that's part of an estate plan that would be in the beneficiary's interest to do that during his lifetime. There are numerous examples of what would be in his best interest to do, but the changing of the beneficiaries, the ultimate beneficiaries, that would have to be in the settler's best interest.
Can I ask you, I find it a little confusing how the trust provision, the statutory provisions governing trusts and the authorities conferred by the power of attorney interact. And so at the time of this amendment, I guess it's right that nephew, Mr. Garner, was both a trustee and an attorney, in fact, under the power of attorney. So he was wearing two hats. His conduct is regulated by bodies of law that relate to both of those two hats. So I get that. And there is a provision in the trust statute that seems to authorize people with powers of attorney to amend the distribution of trust property, including designating different beneficiaries, if and only to the extent that, but thus also presumably to the extent that that's expressly authorized by the terms of the power of attorney. So if the Trust Act says that, go ahead and do whatever the power of attorney says. You can't do more than that, but you can do that with respect to changing beneficiaries. Then what I'm a little unsure of is whether that means that if the power of attorney, if the person acting as attorney in fact has authority under that provision to make that change and also under the power of attorney, are the remaining provisions of the Trust Act about loyalty or all that nevertheless also applicable, so that whatever authority is authorized here is still subject to the general provisions of the Trust Act, or whether this just tells you for purposes of the Trust Act, if you have a power of attorney, you're like the settler, and the settler doesn't have authority, doesn't have responsibilities. The settler can change whatever the settler wants to do about the trust within certain kinds of limitations, but pretty expansive scope. So that's why I'm a little unsure whether there are residual limitations on the power of someone who's authorized by a power of attorney to change a beneficiary in a trust to do anything else like a mere trustee would have to do, or instead whether this contemplates that that person is treated like a settler and really has no obligations of the kind that a mere trustee would have.
I understand the court's question, and to respond to that, I think we look to the argument that we made that it would, within the public policy sphere, that a power of attorney can act, provided that it is done with the purpose of doing what's in the best interest of the principal.
And I get the idea
Yeah.
that even if that's the right way of looking at what remaining statutory obligations under the Trust Act might apply, there may well be limitations on what a power of attorney can do about that, both in the document itself, which your side has made arguments about, but also on extrinsic principles of law, which seem to be acknowledged. So I get that this point is not at all fatal to your argument, but I just ended up being unsure that there are any provisions of the Trust Act about what it normally requires of people who are acting solely as trustees that apply for someone who is authorized under a power of attorney and thus under the Trust Act to essentially be like the settlor for purposes of amending so I'm just a little unsure whether any of the other provisions of the Trust Act are directly applicable to what Mr. Garner, what nephew Mr. Garner did.
I think that the Uniform Trust Act is applicable to what the attempted amendment is in this case, with respect to the amendment, because the original trust was executed in 2001. The attempted amendment was executed in 2020.
Oh, no, I agree. It's temporally applicable.
Okay.
My question was more about whether the Trust Act itself tells you if you are someone who's not a mere trustee, but instead you have a power of attorney that authorizes you to amend the trust document, then maybe the general obligations on trustees may not apply to you, and you're allowed to do that subject to what the limitations are on people who have those kind of powers of attorney. That's what I'm a little bit more
Can I
Oh
point you to 1913.06.02, and under C, it says a settlor may amend a revocable trust under certain requirements. And then under E, it says a settlor's powers with respect to revocation, amendment, or distribution of trust property may be exercised by an agent under a power of attorney only to the extent expressly authorized by the terms of the trust or the power. So that section seems to take you from the terms of the Trust Act directly to the contractual language of the governing document, which is the power of attorney.
Correct. And I think that the pertinent part in that code section, you're talking about the settler. And so I think this goes back to Judge McLeese's question. Is a power of attorney, is an agent under a power of attorney a settler of a trust or have the authority to act as the settler? And I think in this specific case, when you look at the trust specifically defines the settler. They refer to John Michael Garner as the trustor. He's the one who reserves the power to name the beneficiaries of his trust. The trustee does not.
Well, no, but he wouldn't, but my point is he wouldn't be acting as trustee in that capacity. He would be acting as, he would be in the shoes of the trustor via the power of attorney.
And then I think you have to go to the common law principles of what is the fiduciary duty of the agent under the power of attorney. He is to do what the principal wants at all times.
But I
And
think
what he
that
thinks is in-
subsection E refers you not to fiduciary duties of good faith, but you have the power that is exercised only to the extent expressly authorized by the trust or the power of attorney. So if the power of attorney expressly authorizes this, then what's the problem with it?
Well, it's our position that the power of attorney does not specifically authorize the acts that happen in this particular case.
And you're relying solely on section 4 for that.
No, I think the entire power of attorney. So if you look at the nature of the power of attorney, the purpose of the power of attorney is to do what's in John Michael Gardner's best interest on his behalf. It talks about taking care of his health care, his finances, taking care of him personally, what he could do on his own behalf. The focus is John Michael Garner, what is best for him.
So can I mean, we've been in hypothetical land here for a long time. It's like law school, but I mean, we did the one direction on the Texas A&M hypothetical, right? Let's go in the other direction. Your client loses out one way or the other, but Mr. Garner changes the beneficiaries to a different Catholic charity and to not the University of Texas, but a private entity that is a booster for the University of Texas. So essentially achieves Elder Mr. Garner's interests, but your clients lose either way. Would you say you don't have a good faith argument, bad faith argument at that point?
My position on that hypothetical would be that any act to change the current beneficiaries is in direct contravention of the decedents, the trustors, the principals' expressed wishes. And so unless there's some, and in this case, there wasn't any evidence that he wanted anyone other than the current beneficiaries to be identified and named in his trust. He had 19 years to do that. He did not do that. The record is very clear. Patrick Garner had no information about his uncle's estate, never knew he was named, never talked to him about it. When he learned about his position, his uncle was completely incapacitated.
And so then the next step of your argument would be that there's no agent can amend the beneficiaries of a trust without affirmative evidence that it was sought by the trustor.
That the principal, the trustor, either desired that change and didn't have the ability to affect that change, or expressed directly that the trustor wanted to make that change. He had capacity, he could make that decision. All of those facts are not. the
Couldn't it
facts
also,
in this case.
this is kind of academic, I guess, but I thought that one of the other reasons for powers of attorney like this are in circumstances where a change, the circumstances in the real world had changed such that you would end up thinking, and let's say in a setting where the settler is now incapacitated, so you can't consult and there's no indication of a change of thinking, but I mean, let's say that there was a lot of evidence that the reason that the decedent Mr. Garner really loved the University of Texas at Austin was because it was in Austin and it, moved to the University of Texas at some other place. And the attorney, in fact, ended up saying, I just don't think he would have wanted that. What was really driving that was something that existed at the time he did it. It's now changed. That would also, in your view, possibly be a good faith. revision also. So it doesn't have to be a change in the thinking of the settler. It could also be a change in the circumstances that would make you think that the settler's old thinking would have required a new or supported a new beneficiary.
As your hypothetical is presented, yes, I think that would be the case, but that's not, reflective of the facts that were presented to the trial court, and that the.
Well, I mean, I don't know how fully fleshed out this is, but I think your opponent's, one aspect of your opponent's theory takes that form, at least arguably, which is what was going on at the time. This is a paraphrase, but if I understand it, it was what was going on at the time of designating charitable folks rather than his family, maybe not direct descendants, but his family, was that he really wanted to disinherit one disfavored person. And since that original designation, that situation has changed so that you could benefit family members, but not directly, favor the disfavored brother. So there's at least some argument that takes that abstract form, whether it was adequately supported, a different topic.
And my response to that is all of that is his speculation. He had no conversations with his uncle at all. He'd never been to his home until after he was called by Mr. Leo to say, will you take over as agent and trustee? He had no conversations with his uncle. So it's speculative that would not be presented to a trial court as evidence because Patrick Garner didn't know. He never talked to his uncle about his wishes whatsoever. And I think the evidence that is in front of the trial court or the information is that this estate plan was intact for 19 years.
And do you have a view about some of the procedural questions we were exploring with the other attorneys on whether how the summary judgment standard fits in and whether the trial court made a finding of fact that is entitled to deference? And if so, how that happened on summary judgment? Do you have thoughts on that procedural set of topics?
Yeah, I agree with my colleague. I would not be supportive of a remand for a good faith finding. I don't think that that is really necessary for the court to affirm the trial court's ruling in this case. I think that.
Would you say the trial court found bad faith as a matter of fact?
Under the Uniform Trust Act, yes.
And how did the trial court make a factual finding on summary judgment?
Based on the interrogatories, the deposition testimony that was submitted in support of the summary judgment motion.
But what was the undisputed? Yeah, I mean, what was undisputed with respect to bad faith? I mean, that wasn't undisputed, right?
Well, to be clear, the good faith argument that we've talked a lot about today, that wasn't raised in the underlying summary judgment motion. That's something that the appellant has conceded to today. And so with respect to the information that the court had, the information came from largely the deposition, the interrogatory answers that were submitted in connection with the summary judgment proceedings. Patrick Garner, being an attorney, he understood his fiduciary duties to his uncle. He did the ultimate money grab and changed the beneficiaries, knowing his uncle was going to die in a few days, to himself.
I want to make sure I follow the point you were making about what was contested when in the trial court and what its logic is. I mean, I remember that both parties had kind of cross moved for
Yes.
summary judgment. And my impression, though this is a little imprecise, I fear, was that your opponent in seeking summary judgment was not so much as a matter of law, this was good faith or any of that. That was their theory seemed to be it didn't matter. Good faith was really not part of the legal analysis. And are you making some kind of a sort of procedural default argument that if they had wanted to contest that, if they wanted to contest factually good faith, they needed to do something different in the trial court than they did? Is that was that the thrust of your comment?
Well, the argument that Patrick Garner raised below was that he had the absolute authority without limitation to make this change based on the power of attorney. That was the argument below. And that's what the trial court ruled on and made a finding that no, he did not as a matter of law.
Well, yeah, and that's not so much necessarily a finding in factual terms, that's a legal conclusion, but the
Right.
trial court did also seem to articulate a conclusion that there was bad faith here. And I just am a little unsure about whether the trial court thought it was making a factual finding or whether it was doing something that was more summary judgment-ish, and I'm still, I guess, a little blurry about that.
My reading of the order was that it was a legal finding that she was making under the Uniform Trust Code
A legal finding of bad faith. You think that was a question of law?
based on the statute. There are no other questions? Thank you, Honors.
Ms. Edwards, you'd reserved a couple minutes for rebuttal if my notes are right, so we'll give you a couple minutes.
Yes, just a few quick minutes. There are just 2 points that I would like to make for the court. First, on the finding of bad faith, I don't believe, I think what was found was an error, and that was that there was a breach of the duty of loyalty where there was no duty of loyalty that lied. And I think that the entire factual basis was also erroneous, clearly erroneous, because it was solely based on my client not having previously discussed these matters with his uncle, which is not a disputed fact. But my client did contest that that was bad faith in the underlying proceeding because he was expressly authorized by the documents to take the action that he took. I don't think that there is any reason for the court to go into any further factual findings on this matter. The authority to change the beneficiaries in the durable power of attorney is the evidence itself. It specifies that he was authorized to change it to himself personally without self-dealing. It was reflected in other provisions in the testamentary documents that would allow him to provide for the relatives of the decedent. So there is a good faith basis that he was intended to provide for the relatives of the decedent within his powers under the power of attorney.
So the discussion of bad faith by the trial court is in the section about section 4. And section 4, as I've alluded to, I think only applies to liability in the event that your client was sued. So do you think that section 4 has some work to be done in construing the amendment?
No, Your Honor, and you mean section 4 of the power of attorney, which talks about the limitation of the exculpatory clause. I believe that's wholly inapposite. That involves application to transactions. Transactions are defined within the code to mean buying, selling, things of that nature, not changing an amendment to the trust with regard to a beneficiary designation.
It's inapplicable because it applies to transactions, not because its entire scope is only in the course of liability.
And it is in the course of liability. I don't believe that it modifies any of the estate planning authorities given under the power of attorney based on the structure of the power of attorney itself. And as I was saying, I don't believe that it's necessary to remand or for the court to find any further evidence on good faith because it is expressly manifest in the power of attorney document. And I'll point to the restatement provision that authorizes this. It is in my brief. It is restatement 2.021 comment C. It explains that a manifestation may include the principal's written or spoken words and that a formal written instrument is often dispositive of the question of reasonableness. And to quote it, it says, if the principal has stated the agent's authority in a formal written instrument, the formality of the statement itself is relevant to and often dispositive of whether the agent could reasonably believe that the principal intended to consent to the agent's power to do acts beyond or other than those stated in the instrument. So here we have a power of attorney that does not cease upon the disability or incapacity or incompetence of the principal. And the expressed intent of the principal is not to provide for particular charitable beneficiaries under every circumstance. It was to the contrary, to authorize his nephew specifically to change the beneficiaries, to amend the trust as necessary, and to give gifts to himself and other relatives of the decedent as he believed was proper.
So not to get onto something ticky-tacky, I thought he wasn't allowed to give gifts to himself under section 3.
Of the power of attorney?
Correct. Let me see if I can find it.
Power of attorney, article 3, section C, paragraph 1, had the authorization to make no consideration gifts from the trust to himself without self-dealing.
Okay, I guess I'm looking at appendix page 260. In no event may any gift be made from my assets to attorney in fact, except as is appropriate for the health, maintenance, support, or education of my attorney in fact.
That's a limitation on the ability to give gifts, Your Honor. And I also believe that there's a second limitation. I don't think under any circumstances under the power, he was allowed to give any gifts for any sort of liability, or not gifts, but any distributions to satisfy any liabilities that he owed, such as child support or things like of that nature. So I think that that's a distinguishable thing. I think the overarching theme in all of these documents, the trust and the power, which I agree with my colleagues, should be read together, is that the decedent, as reclusive as he was, intended to give my client the authorization that he did, and that it was sufficient authorization under the common law in effect at the time. I think one other distinction with the new statute, just to clarify my client's position on this point, is that the statute goes a little bit farther than the common law that was in existence at the time the power of attorney was executed and at the time that the power of attorney was exercised. And the distinction is that it requires specific express authority to change beneficiary designations beyond just the overarching statement that you have all powers to act on my behalf. And
although in your view, that is not a material difference because
it already does.
That existed
Correct.
here. Is that right? Can I ask you, just back to the question that Judge Ollicott was asking you about the limitation on the ability of your client to give himself gifts during the lifetime of the settler. Are the words, that limitation there, I mean, there's several, but the one that I'm focused on is that no gift can be given except as is appropriate for health, maintenance, support, or education. Are those like terms of art of some kind?
They're a standard used in estate planning language. And I would just say that there are two gift giving provisions in this entire estate plan. This is the one under the power of attorney, which does provide this ascertainable standard limitation, but the provision in Article 3 of the trust has absolutely no limitation. I'm sorry, Article 5, which says when I am incapacitated, my successor trustee, one and the same person, can make unlimited gifts to my blood relatives. That's what it says specifically.
Right. And just to be clear, I without getting way into what those limit, what that well settled meaning of health, maintenance, support, or education is, that would not have permitted him to have said, I am going to give all $3 million of the value of this estate to myself while the decedent is alive, with soon, like all of us, future decedent is alive for my maintenance and support.
I think there are limitations that would apply to his capacity as the power of attorney.
I understand that. I just meant, leave aside that, it is the idea of devoting funds to someone's health, maintenance, and support, if that's a paraphrase of them. I'm not sure I have in the right order.
Yeah.
Is that impose some kind of limits about you can't give somebody $3 million in lump sum for their health, maintenance, support? It has to be something that's really more tied to their proven needs, or
well, it's a little bit more complicated than that, but it gets
Okay,
into
really
discretionary standards that I don't think are at issue in this case. And we're not making the case that he was making unauthorized gifts to himself during his lifetime.
no, and I don't want to waste any further time on it. I've already wasted so much, for which I apologize. I was just, to the extent understanding these documents as a whole is informed by what the various provisions and how they fit together. I was just trying to make sure I understood that little piece of the puzzle, but it's definitely not worth more time. So I apologize for
No, not at all.
delaying you. And if you have, we're well over time. If you have a minute or two you want to wrap up on, that'd be great.
No, I thank the court for the extensive time that you've provided today and for bearing with me as I'm losing my voice. I was up all night with my dog at the hospital. So I would just like to wrap up and say that, the intent is clear here, that there was no finalized intent to, under all circumstances, provide for these charitable beneficiaries. Instead, there was always an intent to authorize my client as his nephew to make these decisions within the reasonable bounds that it provide, either for him without self-dealing or other relatives of the deceased. And I ask on behalf of my client that the court reverse the ruling of the lower court. Thank you.
Thank you, counsel, for their briefs and arguments today. The case is now submitted and we will stand adjourned.
Thank you.
All right. This honorable court is now adjourned.